Hi guys, it's Kathy. I hope you're doing well. We made it to OJ. Let's check her out. Good? Good? We're good? Here we go. Oh.
Prosecution both sought to retest the tissues. Obviously, the defense, desiring to preclude the kind of argument proffered by Dr. Readers that their tissue was simply older and that explains the lack of oleandrin, the defense requested that they retest the same tissue. The prosecution also requested the same retesting, and they independently submitted samples to Dr. Henyon. And so you have two separate reports generated, one to the defense, one to the prosecution, and each of them submitted their own samples. Now, Dr. Readers, I proposed two things. What you can see in one of the reports is that there were samples delivered by Dr. Readers via Federal Express from his lab. In the other report, you have Dr. Finkel. The difference being that Dr. Finkel hand-carried some of the samples, and Dr. Readers, via Federal Express, mailed some of the samples. And one went to the prosecution and one went to the one came from the prosecution, one came from the defense. Hence the difference in the listing of samples tested in the two different reports. That's that. Dr. Readers has, I propose to show him a bill which indicates that there was a shipment of specimens to Dr. Henyon, and that was this bill is dated for 1991. He's billing for the expensive shipment of those specimens. Because the billing entry is ambiguous, we asked that Mr. Blazier have Dr. Readers bring in his file with the chain of custody documents, and we were told to pound sand. So we are now going to request of Dr. Readers that he examine his file for the chain of custody documents to indicate the tissue samples that he did surrender. We do know that he did surrender frozen tissue samples that he had from the 85 autopsy to Dr. Henyon, in addition to which Dr. Lovell gave...
Why don't you just ask him that?
I will, but I believe that he doesn't have them.
No, why don't you just ask him, did you give the 85 samples that you had still in your custody to Dr. Henyon for testing with regards to this case?
I believe that I did, Your Honor. He said that he offered it, but it was rejected. That was his testimony.
All right, so what is this bill going to show us?
Well, he shipped tissues. It may indeed impeach him. He shipped tissues to Dr. Henyon.
How do we know it's the 85 tissue?
Why would you ship only the exhumation tissues if you have both in your possession? You're right. I mean, it doesn't make any logical sense that he would do that, especially when we have letters from Roger Diamond, the defense attorney, indicating that he desired to retest the same tissues for the obvious logical reason that if he doesn't, the people will not be convinced to dismiss the case, which is in fact what happened. So that's why there were two ways that Dr. Henyon got the 85 autopsy samples. From a very simple and broad-based point of view, Your Honor, this witness has attempted to represent to the jury that the only reason there were negative results by Dr. Henyon is because he never tested 85 autopsy tissues, whether they came from him or someone else. He has denied categorically, based on his review of everything he has seen, that Dr. Henyon ever tested such tissues from the 85 autopsy. A very simple impeachment method is to say, look at this, does that change your opinion?
Did you show it to him over the
Yes, I did.
hand during the break?
The video?
Yes.
Yes.
I thought you meant the receipt.
The break.
The,
All right.
the video was shown to him.
Yeah,
yes.
he did. He has no
Well, he
idea what
didn't
it is.
refresh his recollection. Of course it wouldn't refresh his recollection. That's not why it's being shown. It's being shown to see if it will change his opinion as to whether Dr. Henyon received 85 autopsy tissues for testing. His answer either way is going to be illustrative, and it's one question.
And you're going to bring in Dr. Henyon at some point to say, I tested the 85 autopsy stuff, and it's included in my report as sample R something.
That's right.
Dr.
That's right.
Henyon-
Actually, two different autopsy samples, one from Dr. Readers and one from the cutting made by Dr. Lovell in 1991.
All right, so haven't you already asked and established the negative answers?
No, not with respect to this. And I think it is germane to, this is cross-examination, and the witness's refusal to accept an obvious fact in order to change his opinion, or if he does, to change his opinion, is clearly relevant to his credibility. It's one question and a 1-minute video to demonstrate graphically that it doesn't matter what this witness has shown. He's never going to change his opinion. And I think that's highly relevant to his confidence and his credibility, which the jury has to assess.
Mr. Blazier?
Collateral. It's incredible. Now I have two reports that look the same on the surface, but they're different. And the reason they're different is because some tests are included in one that aren't included in the other. The one that Dr. Readers has is he got one report. He didn't get both reports. This is outrageous. I think if we're going to go into this at all, he needs an opportunity to at least see the second report that was not sent to him. This is so confusing. I can't tell what's in one and what's in the other now. They look the same when you look at them, but when you start comparing samples, they're different.
Well, the same conclusion.
Yeah, the same conclusion is that the absence of these analytes at the time of the analysis does not mean they were not present at an earlier time. Little is known about the chemical or enzymatic stability of these substances over time under the conditions of storage experienced by these samples. So regardless of what's included in both of these reports, he comes to the same conclusion. That is, he can't say that Readers was wrong.
I disagree with counsel's characterization. There is a qualification issued by Dr. Henyon, but we come to a larger issue then. Really, had Dr. Reeders known of the appropriate and most sophisticated method of testing back when he did the testing in 1988, it would have been better confirmed or refuted that the presence of oleandrin was there, that there was oleandrin present in the tissues. His failure to know of the most appropriate testing.
But we've already talked about that.
Okay, nevertheless, all I'm asking
The
you to do...
only issue then here is whether or not Dr. Henyon tested the 85 autopsy specimens. That's correct. You've already asked him that. He said to his knowledge, no, he didn't. Correct?
He's done more than to say to his knowledge, no. He is saying no categorically, he did not.
All right, and you're going to bring in Dr. Henyon.
Yes.
Okay.
So the court, the people have some very graphic evidence that takes no time to confront the witness with to see if he will change his opinion.
That's probably one of the worst videotapes I've ever seen. I mean, I've seen 9-year-old kids take better videotapes than that.
Well,
I mean, it's going all over the place. You can't tell what it is. It doesn't focus in on a date and time.
yes,
I mean,
it can be freeze-framed to show that this is autopsy tissue. And it's narrated. Your Honor, I didn't make this videotape, obviously.
obliquely. But see, this is such a collateral issue. If you've established already that he says he didn't have the 85 autopsy, that the 85 autopsy samples were not considered by Dr. Henyon, and Dr. Henyon comes in and says, yes, I did have the 85. I came to a contrary conclusion than Dr. Reeders. I disagree with, his professional opinion. So that's the point. And you don't need to show this. And if you've shown it to him and it doesn't refresh his recollection, then there's no basis to show it. I'll allow you some leeway. And I have to tell you, this is an incredibly confused situation to now have two of these technical reports, which appear on the surface to be identical. But if you look at them carefully, they talk about different things at different points and different times. Maybe it's because I'm tired and it's been a long day, but I'm completely confused reading these two reports. Because they're not the same reports and they say different things. So
Well,
at this point, you can ask, just restate that, to set where we are, that Henyon, in his opinion, Henyon didn't test the 85 samples. That's the end of the inquiry. I find the videotape, since Dr. Reeders has already seen it, doesn't refresh his recollection as to what it is. I'll sustain the objection at this time.
May I show him his bill?
You can see if that refreshes his recollection. All right, let's have the jury, please.
Without a full description to the jury of what it is.
No, I don't think that's appropriate because the jury needs to know what it is that's being presented. And if it does or does not refresh his recollection. Here's the billing. Do you recognize it? Does that refresh your recollection as to what was sent? That's what can be asked.
What about using the report?
No, I think we've already established that. You've asked the question.
No. That was the defense report. There is the other report.
All right? You can ask if he's seen that other report. Ms. Clark.
I have a document, Your Honor. It has to be marked People's Next in Order 586,
587, I believe.
587. Yeah, I'm showing you what's now been marked as People's 587. Do you recognize the letterhead?
Yes,
That's your letterhead, sir?
the company letterhead.
Okay, let's see if I may.
No. No.
Before the foundation. Is this a bill that you submitted to the prosecution for your work in the sconce case, sir?
I haven't looked at it. Let
Oh.
me look at it. I just looked at the letterhead. That's a bill. Yes.
Is this the bill that you presented to the prosecution for your work in the sconce case?
I really don't know. The company did, evidently. I didn't.
It says to Mr. Harvey Gist, Deputy District Attorney, is that correct?
Right.
And it says for professional services, Ray
Right.
Timothy Waters, David Sconce, accused, correct?
Oh. Right, that's what it says.
All right, does that seem to be then the bill for the services you rendered on the sconce case to the prosecution?
Yes.
Now, dropping down to the last paragraph where it is circled in black, do you see a reference there to the examination, securing, storage, and shipment to Dr. Henyon?
Yes.
Does that refresh your recollection, sir?
Absolutely
as to
not.
what tissue samples you sent to Dr. Henyon?
Absolutely not. The only thing that I can surmise is that the samples that Dr. Lovell sent to me, I forwarded to Jack Henyon. But I have no recollection of this at all. It may have been done by my secretary for all I know.
Then is it your testimony that this is a reference to the exhumation tissues that were removed from the body in 1991?
Oh. I have no idea what this is. I think that it could be that Dr. Lovell shipped to me his half, and I shipped it on to Henyon, or my secretary did.
His
But
half of what, sir?
whatever was taken at that autopsy,
At the autopsy
at the
in
second
91?
autopsy in 91, yeah.
But in your opinion, this does not reflect the shipment by you of tissues that you had from the 85 autopsy?
Absolutely not. I was strictly informed not to ship anything of my own specimen. I think I still have it in the freezer.
Doctor, was it asked of you, pursuant to a letter written by the prosecution in this case, to bring with you to
Hi,
court today
Bobby.
your chain of custody documents that reflected the movement of the tissues you had from the 85 autopsy?
Sustained.
Do you have in your possession today a copy of your chain of custody documents that indicate the movement of the tissues that you received from the 85 autopsy on Timothy Waters?
Up to point, yes. Up to July 88, not July 88. Hold on. Yeah, July 88.
And July
That's on
88, I'm sorry?
That's on one of the sheets, yeah.
July 88 is when you concluded your testing, is that right?
Yeah, just about. After that, they stayed in the freezer. That's all I have.
So you have no documents to indicate what occurred to those tissues after you completed your testing?
Yeah, they went into the freezer and stayed there. I think they're still in there.
That's your testimony?
They went into the freezer and stayed there. Yeah, I took him out when Mr. Diamond came to show him to him. He wanted to see them. That's all I recall. After that, I don't recall ever getting back to them, except that when we moved the freezer, I saw him still in there, which was maybe months later.
Do you recall Dr. Brian Finkel, the defense toxicologist, sir, approaching you to get a split of your autopsy tissues?
In Anaheim, yes.
And do you recall...
Not reproaching me, I approached him. He approached me to look at my tests, and I told him, do you want some of what I have? That's all.
So do you recall him asking you for a split of your tissues and you refusing to give them because you were precluded under Pennsylvania law? Do you recall that, sir?
Absolutely not. That's untrue.
And so if he so testified, he would be mistaken. Is that your testimony?
I said it's untrue. But if he so testified, then he's very much mistaken.
Let me show you. I'd like to mark that People's Findings, Your Honor. Another report by Dr. Henyon, entitled Final Report from the Analysis of T. Waters Tissue Samples Submitted by the Prosecution, People v. Wisconsin.
So, Mark,
Directing your attention, sir, to page 5, in which it indicates tissue samples provided.
it is at this point, Foundation Counsel, using this to refresh his recollection.
Yes.
All right. Why don't you review that briefly, Doctor?
I'm asking you to review the legend.
May I look at the whole?
Sure.
While he's doing that, let me see counsel at the sidebar without the report.
The judge did try to tell her, why are you asking these questions? Why? We've been over it.
Yes, I reviewed.
Do you see your name mentioned?
Yes.
Does that help to refresh your memory as to whether or not you mailed or sent Dr. Henyon some of your 1985 autopsy tissues?
No, it does not. May I see my own report that I gave you a while before? This is different from my report. This is a changed report.
No. Sir, are you aware that there were 2 reports prepared by Dr. Henyon in that case? One for the defense and one for the prosecution?
Yeah.
Did you know that?
No, I didn't know that. Well, how would I know that?
Bobby,
got my
you're a
report from Harvey
saint.
Giz. That's
You
all
know
I
that?
know.
A saint.
Do you see an entry on your bill that's still in front of you on the witness stand, sir, that indicates that you had conversations with the coroner, Dr. Lovell, pre- and post-exhumation?
Yes, I see that.
During the course of those conversations, you were informed, were you not, that both the prosecution and the defense were requesting retesting by Dr. Henyon?
Hearsay. Sustained.
Did you discuss with Dr. Lovell the reason for the exhumation in 1991?
As I recall, I told him what I understood was the reason for all of this taking place. Yes.
And what did you understand was the reason for all this taking place?
Objection, irrelevant.
Sustained.
All right, sir, you indicated that you cannot identify any compound at any time. We're done with that, sir. You indicated that you could not identify any compound at any time to the exclusion of all others. Is that correct?
In my opinion, nobody can, and I certainly can't. I'd like to meet the one who can.
And you indicated that in order to do that, it requires faith. Is that what you just said?
Require what?
Faith.
Well, you can say you did, and that's an article of faith, but it's not an article of science, because you can only exclude it if you compare it with all other compounds in existence, which includes the ones we don't even know of. So it's absurd.
And so you have testified in this case that although you cannot say that the substance found in the gate and the sock are EDTA from preserved blood to the exclusion of all other compounds, you have indicated that in order to say that, it would be an act of faith, correct?
Argumentative.
Of course I can't. Nobody can.
And isn't that exactly what you said in the sconce case when you claimed to have identified oleandrin?
Objection, argumentative.
Sustained.
Wasn't that the very language you used, sir, when you testified at the preliminary hearing in sconce that you had identified the presence of oleandrin, which was later refuted by Dr. Henyon?
Objection, irrelevant. Misstates the testimony.
Sustained.
Nothing further.
Doctor, thank you.
All right, thank you very much, Doctor. You may step down.
Thank you.
All right, next witness. All right, do we have the witness available? All right, let me ask the jury to step back into the jury room for just a moment.
Why? What's happening now?
All right, record should reflect the jury is withdrawn from the courtroom. All right, next witness by the defense is Michelle Kessler, correct?
That's correct, Your Honor.
All right,
Wait.
Mr. Goldberg, do you want to state your objections at this point?
Wait. It's only August 14th. There's no way Michelle Kessler should be up yet. Offensive
Your Honor,
language
we filed
warning.
a brief on Michelle Kessler, and we had a number of different objections to her testimony, one of which related to the news leaks, and I think that's been dispositively resolved now, although not 100% sure, but I think so. And I think probably counsel understands that based on the court's earlier rulings, they would not be allowed to inquire. But I think we need to make sure that that is their understanding. For the record, there were several other items that were also contained in the same brief. One was that the defense should be precluded from inquiring of Michelle Kessler as to the status of her husband as having a job with robbery homicide. He works for robbery homicide, and he works in the division that investigates bank robberies. We argued in our brief that that's entirely irrelevant on the issue of this witness's bias or any other issue. The other item that we'd like to preclude is we'd like to preclude any questioning to the effect of trying to imply or suggest that Michelle Kessler has a bias to testify adversely to the defendant because of any anger towards the defense attorneys. I'm not positive that they intend to get into these areas. And perhaps if they make an offer of proof, we could discuss them at more length. Another item that we wanted to preclude was any impeachment on what we would regard to be a collateral issue. That is that at the Griffin hearing in the municipal court, Michelle Kessler testified that a certain item of evidence had been sent out for testing, or she said that it has already been sent out, is the way she phrased it. And in fact, the item, excuse me, she said it's waiting to be sent out, or it's ready to be sent out, is I think the precise language. And in fact, the item had already been sent out to Cellmark. It is not relevant to any issue in this proceeding and is therefore collateral. And then finally, Your Honor, on the issue of policy, if that is the only issue that counsel wishes to address, and I'm not sure that it is, we believe that there has been extensive testimony in this trial about the policy of the Los Angeles Police Department from a number of witnesses. Michelle Kessler is not an expert in policy. She doesn't really have any more knowledge of it than any other witness from SID.
The
per
lab
se.
director isn't an expert in policy?
No, because the policy, in terms of the Los Angeles Police Department policy manual, is promulgated by uniformed police officers. And they spent a lot of time asking them about the Los Angeles Police Department policy manual. And she did not write the manual. She did not participate in writing it. So we believe that under 352 it should be excluded. I have other arguments on many of these items, but I don't know exactly which ones, if any, the defense intends to get into. So on those 5 issues, the husband, policy, the impeachment on the collateral issue involving her testimony at the Griffin hearing, any suggestion that she's angry at the defense, and the leak issue, all of those they should be precluded from questioning her about. And I don't know whether they intend to question her at all if they can't get into the leak. So without hearing from the defense, I don't have anything further to say.
All right, is she
on those at this
immediately
time.
available, by the way?
She's upstairs.
All right, why don't you have her... Mr. Fairlow, is she on her way?
Sent a message, I'll ask her to come back. She should be
All right. Mr. Neufeld? Ms. Kessler, would you wait outside, please? Thank you. Mr. Neufeld?
There's actually a series of different issues here. Actually, Mr. Goldberg is raising additional objections now, which were not contained in the initial papers on Ms. Kessler, and I can address that as well. It's not a problem. Let me say this: the one objection that they made in their papers was to my inquiring about Ms. Kessler regarding the leak concerning the socks. There was no application to preclude me from asking her questions about the other leaks, which turned out to be accurate and reliable. And I wanted to discuss that first because I think that's the most important issue, Your Honor. I think the issue involving the husband is, I mean, they brought out the husband on cross-examination, on redirect examination of their own witnesses. In fact, Mr. Goldberg is the lawyer himself who asked those questions. So the jury is already aware of the fact that Ms. Kessler's husband works in robbery homicide in the same unit as Van Adder and Lang. The fact that Ms. Kessler testified untruthfully, in fact, at a hearing on June 30th, when she said that items 49 and 50 were ready to be sent out in the future, and then acknowledged at the Griffin hearing later on that, in fact, she knew that they had been sent out on June 21st, 9 days before she testified in this case, I think, frankly, goes to her credibility, the fact that she was willing to lie under oath about that matter. So I think that that's plainly the kind of impeachment that is permissible under the evidence code, under any applicable case law in California that I'm aware of. But let's deal with the most important issue. The most important issue, I think, Your Honor, is the leaks. When Mr. Ullman made his argument with respect to Tracy Savage and Mr. Bosco, he mentioned about the possibility that there was not adequate security for the information contained in these reports when they came to the Los Angeles Police Department, that there may have been gossip and information may have gotten out to unauthorized personnel that way. We do not intend to make that argument with Ms. Kessler on the witness stand. That is not our contention at this time. It is our contention, Your Honor, that, and by the way, part of this comes from the 402 hearing where Ms. Kessler testified. Part of the proffer comes from an interview that Mr. Scheck and I conducted with Ms. Kessler before the city attorney at their offices a few weeks ago. And part of it comes from other testimony of other witnesses in this case. And it is simply this. On or about September 12th, the SID unit, specifically Michelle Kessler, received 2 reports. One is the Cellmark report dated dated September 8th. And the second is a report from the Federal Bureau of Investigation regarding the hair and fiber analysis results. Both those reports were received at about the same time. On September 14th and 15th, there were news stories in the Los Angeles Times and other newspapers describing both the results from the Cellmark report on the Bundy blood drops, that it was consistent with Mr. Simpson, and secondly, also summarizing the FBI hair and fiber results, saying that a hair found on Mr. Goldman's shirt was consistent with Mr. Simpson. That fact is in fact contained in that FBI report dated September 7th, 1994, but received presumably at LAPD a few days thereafter. It should be noted, by the way, that the FBI report was not received by the defense until, I believe, September 26th, which is about 11 days after it was reported in the Los Angeles Times. So you have both of those reports arriving at SID addressed to Michelle Kessler on or about the 12th. Could have been the 9th or the 10th for the FBI report, but it's very close in time. And the subject matter of both of those reports are included accurately in newspaper reports on the 14th and 15th of September. Michelle Kessler testified that those reports were kept in a secure facility. They were kept under lock and key in Mr. Matheson's office in serology. That was elicited during the 402 hearing before Your Honor, I believe, a week or two ago. And she was very, very limited as to who had authorization to those reports, because the case was being treated as a confidential case. And so the reports would not be kept in the normal routine with the serologist, but instead would be under lock and key in Mr. Matheson's office. Now, it is our argument that if individuals, perhaps not Michelle Kessler, but if other individuals had unauthorized access to those reports, those same individuals could have unauthorized access to the items of evidence. And the nexus is simply this, Your Honor. These socks were not kept under lock and key in the evidence control unit during any of the relevant time periods. Susan Brockbank testified that the socks were taken out of the evidence control unit on June 21st of 1994, and they were stored in serology. That's the same place where these reports were stored, from June 21st, 1994 until August 4th, 1994. So they were not kept in a secure fashion. Indeed, the evidence will show, and I believe Ms. Kessler will have to acknowledge it under oath, that the reports of the results were retained in a more secure way than the socks themselves were in this case. I intend to elicit that from her. I believe, Your Honor, that we are allowed to argue the inference that if the reports themselves were not sufficiently secure as to prevent unauthorized access, because clearly there was unauthorized access because Michelle Kessler has testified that neither she nor the individuals who were allowed to have access to this report communicated with the media and were responsible for this leak. Then
Well, refresh my recollection, but didn't she also testify that after receiving those results, she communicated those results with the investigating officers in the case?
Well, as to the FBI report, we don't know anything yet because I didn't go into that during the 402 hearing, so I don't know who it was communicated to or when it was communicated to. As to the Cellmark report, she didn't know when or to which investigators the Cellmark information was communicated to. She did testify, and we do know that it wasn't communicated to the district attorney's office until the 16th of September, which was after it was disclosed and leaked to the news media. So we don't have a date on that. The one we have a date on as to who it was in fact released to was the September 21st leak. And what we know about that is that on September 20th, Greg Matheson concluded the conventional serological analysis on the ankle stain on the socks. That Michelle Kessler learned of those results also on September 20th. That together Michelle Kessler and Greg Matheson then called up the district attorney's office and communicated those results to Marsha Clark and Lisa Kahn. That same afternoon, she said she communicated that result to, I believe it's Detective Lang, but I'm not positive. I know that she did say she communicated it to some detective. So that's the circle of access with respect to the PGM results, or that there was any blood analysis done on the socks. It's a very small circle at this point. And the next day, we know that it certainly was disclosed that there was blood on the socks and that the genetic profile on that socks was consistent with Nicole Brown Simpson. So even without the last leak of information, we have two instances where the prosecution has asserted that they run a very secure facility. Remember, they made a big deal on the People's Direct case out of suggesting to the jury that we have all these mechanisms to make sure that items of evidence are not compromised and not tampered with. And I believe we can show that that security is a farce. And the reason we can show that that security is a farce is, number one, the socks were not kept in the most secure manner at SID during the relevant time period. And two, that reports were kept in a more secure way during a critical time period. And nonetheless, it appears, or one could infer from the obvious facts, that the subject matter of those reports was leaked to the press before anyone else had access to it. 1 second. I'm sorry, I thought I made it clear, perhaps I didn't, that during the time that the socks had been removed from the evidence control unit, that is from June 21st to August 4th, they too were simply secured in the serology unit as opposed to the evidence control unit. That's the record in this case. And the reports were also in the same unit, according to Michelle Kessler's testimony at the 402 hearing. The only difference being that the reports were kept under lock and key in a file cabinet in Mr. Matheson's office, and the socks did not enjoy even that degree of security. So if we can show that unauthorized people had access to the reports, then I think that we are free to argue to the jury that if it was that kind of breach of security with regard to the reports, there could have also been a breach of security with regard to the socks. And I think that's relevant, and I don't even think that's a stretch in this instance, given the very, very compelling facts we have as to the reliability of those different leaks, the FBI leak and the Cellmark leak.
Thank you, Counsel. Golder?
Your Honor, perhaps before counsel sits down, he might make an offer of proof as to whether there's anything else they intend to get into other than the leak.
Well,
So we
that's what
could narrow-
that's what I just heard, so.
But I'm just saying so we can save time, because I don't want to address all these other issues again if counsel's going to represent to us now.
Counsel, that's the only one he addressed, so that's the only one I want to hear a response about.
I mentioned the other ones even before, Your Honor, I think in passing, but I think we're entitled to examine her on her husband briefly because they went into it, and I mentioned, I believe, her lack of truthfulness when she testified under oath at an early proceeding.
Perhaps counsel could
I do
indicate,
not
I heard those.
Yeah.
I heard that.
but I also made an argument about policy and whether she's angry at the defense. I'm just wondering whether counsel would offer whether he wants to get into any of these issues.
Your Honor, there's no question that the head of the SID can comment on policies at the SID as the director of that institution. There's also no question
Do you
that...
feel compelled to make this argument?
No, sorry.
Well, I see the monster lives, Your Honor. I just wanted to clarify how many monsters we were dealing with here. I don't know how many times we have to address this leak issue. We've done it now, I think, 5 times, and I don't want to spend any longer on it because the court has already ruled. I thought this was an absolute definitive dispositive ruling that finished it for all time.
No, that was only as far as Tracy Savage and Joe Bosco were
Well,
concerned, so.
if the court isn't going to allow the defense to put in evidence as to these, what the news leak was, the court has precluded evidence as to the airing of this information, and it's not going to allow them to put that on, then how are they going to get that piece of evidence in? How are they going to prove there was a news leak? The court's already said they can't do that, and they can't put on the evidence that would be used to prove that there was a news leak.
Well, in this case, they could trot in Andrea Ford and ask her what she wrote, but go ahead.
Well, yeah, or maybe many other reporters, but I would assume that if the court's not going to allow these reporters to testify to it, the court wouldn't allow some other reporters to testify to it. I hope I don't need to spend too much time on this, Your Honor.
Okay, I'm not suggesting leaks are okay. I'm not. But what does it matter to the actual trial if there's a news leak? The jury can't see it. So, I mean, why are we wasting so much time?
Because, you've heard these arguments so many times, over and over and over again. The court has previously ruled that access to the information does not imply access to the evidence. That is a ruling that the court made. We suggest that that ruling is correct. Our evidence was as to the security with respect to the evidence in this case, not with respect to any information or the reports in this case, and the two of them cannot be equated. Also, Michelle Kessler, the only thing that makes her different from many of the other witnesses that could have testified to this is that she doesn't have personal knowledge of any of these things, as was elicited in the 402 hearing. She does not have personal knowledge of when any of the reports came in, because although they were addressed to her, everything was going through Greg Matheson, and she only knows about them because of what Greg Matheson told her. So if the court just mechanistically applied the rules of evidence in this case that are set forth in the evidence code and did not allow witnesses to testify to hearsay or things to which they do not have personal knowledge, the only truthful answer that she can give when she's asked, when did this report come in, is, I don't know. Because she doesn't know other than from what Greg Matheson told her, which is hearsay. I'd also point out, and I'm not going to repeat many of the other arguments that we previously made, that the preliminary DNA results the counsel was referring to on the 13th and the 14th, the DNA results that counsel was referring to on the 13th and the 14th were preceded by preliminary results in the form of Cellmark's cocktail. And it is also possible that the press could have inferred what the results were going to be if they knew what those preliminary results were. So trying to figure out any logical connection between the source of the leaks and any issue that is at evidence in this case with respect to the integrity of the SOX or any other piece of evidence requires us to go through so many hoops and requires us to make so many speculative inferences that I believe that the court's ruling earlier today is correct, that it is irrelevant under Evidence Code Section 350 and also should be inadmissible under Evidence Code Section 352. Let me just address some of the other issues. First of all, the question of policy, and by the way, we did address many of these things, although not all of them in our brief. Yes, Michelle Kessler can testify to certain aspects of policy, but the question is, are they relevant and should they be excluded under 352? Because we've already spent an enormous amount of time on policy, and I'd just like to quote from the Corish case, which we had in one of our earlier briefs that was filed, I believe, by Mr. Harmon, and I quoted it in one of my briefs as well. And the language there at 52 Cal 3rd, I'm quoting from page 693, where they're talking about the admissibility of evidence of other evidence-gathering techniques is, and in this case, I know the court's somewhat familiar with it, the defense wanted to put in evidence of other electrophoretic techniques that could have been used by the Los Angeles Police Department that were not used, specifically isoelectric focusing. And that was precluded by the trial court. And the Supreme Court held that we agree that it was not material to any issue in this case. The defectiveness of the evidence-gathering technique in this case, if any, is not measured in comparison to other purportedly superior methods. Such a comparison cannot assist the jury in determining to what extent the method employed actually produced probative evidence, nor can it help the jury assign a weight to the evidence. So in other words, when we're trying to determine how well the evidence-gathering techniques worked in this case and how probative they are, we have to look at the techniques we used, not other techniques that we could have used, or purportedly superior techniques. And this is particularly instructive here, because if we find a policy provision that says you could have maintained the evidence this way, or you could have collected the evidence this way, does it really tell us anything about the reliability of the technique that we actually used here? And I think, to paraphrase the Supreme Court, it does not tell us anything about the techniques that were actually used in this case to look at some purportedly different techniques that could have hypothetically been used. So I'd say that I know that maybe this is a late juncture to be arguing this because we've already gone into the questions of policy very extensively, but I'd argue that the issue of policy really doesn't tell us anything probative about what we're inquiring here. And to the extent that it is probative, its probative value is minimal and is clearly outweighed by the fact that we've already spent an enormous amount of time on it with all of our witnesses, with Dennis Fung, with Andrea Mazzola, with Greg Matheson, testifying about the policy manual, how they interpret it, what it requires, what it doesn't require, who it covers, who it doesn't cover, and that any minimum probative value that the evidence has is clearly outweighed by the fact that we've already spent an enormous amount of time and we shouldn't spend any more. Now, as to some of the other items, the issue of Michelle Kessler's husband. It was the defense that brought out the fact on cross-examination of Dennis Fung, how it came in or why it came in, I'm not sure, that Michelle Kessler is the laboratory director and their husband works for robbery homicide. So I guess it is in the record, but we did not bring it in, and we only mentioned it after it was already brought out by the defense, and only in the context of refuting the implication that somehow Michelle Kessler and her husband, because he worked for robbery homicide, and a lot of other people were involved in a conspiracy to frame the defendant, including Dennis Fung. And that was the only context in which we asked that it be brought out. But it is irrelevant. And I think that the case of People versus Kronmeyer is somewhat instructive. And there, what happened was the defendant had embezzled, was an attorney, and he had embezzled client funds from a client who was senile. And the doctor that testified as an expert witness for the prosecution that the victim was in fact incompetent was a friend of one of the beneficiaries of the victim's estate. And the California Supreme Court here at, the California Appellate Court at 189 Cal App 3rd 314, and the discussion is around page 342 through 343, held that the trial court properly disallowed any questions showing the relationship between the prosecution's expert witness, the doctor, and the beneficiary of the estate, because they said that that relationship, that personal relationship between Dr. Corwin and Miller does not itself suggest any bias, and any hypothetical suggestion that a bias in favor of Miller would manifest itself further by being suggestive of Corwin's bias against anyone as to whom Miller was prejudiced is pure speculation. Well, the same exact kind of reasoning is being applied here. They're saying, well, maybe her husband's biased against the defendant because of his association with robbery homicide, and because of her association with him, maybe she's biased. I'd suggest that that's simply too speculative to be allowed. As to the impeachment issue on the question of her testimony at the Griffin hearing, the law is settled in California, and we've cited this in a number of different contexts, that we do not generally allow collateral impeachment. Collateral impeachment is impeachment where a witness is testifying to something that is itself not at issue in the case, and you then want to introduce evidence to prove that that testimony was incorrect. The question of when the items were actually sent out, as opposed to being prepared to being sent out to Cellmark, is not something that is being disputed by the parties. In other words, they're not saying that they were actually sent out on a different date than what we're saying. So the question of when they were sent out is an immaterial issue, an issue that neither side disputes and that neither side is contending is relevant to this case. So what they want to do is to ask her, when were the items sent out? And then to have her say, well, this is my understanding of when they were sent out, and then impeach her with her prior inconsistent statement. So this is a classic instance of collateral impeachment, of eliciting something that is not relevant and is not admissible, except insofar as the defense wants to elicit it from the witness for the purposes of impeaching her with it. And there were quite a few cases that discussed this that we cited in our brief where similar attempts were disallowed. And essentially what these cases have said is that you really can't set up a straw man, and you can't call someone for the sole purposes of eliciting otherwise inadmissible evidence that's not in contest so that you can later on knock down that same evidence. And we suggest that they cannot do so here. It appears that what the defense wants to do is they're more interested in impeaching the witness than they are in actually getting anything substantive from her. So I guess what they want to do is call her maybe for something that perhaps the court will feel has some probative value in the case, such as policy, and say, well, the policy really isn't that you're allowed to put your evidence in plastic bags, is it, Ms. Kessler? And they're saying, no, that is the policy. It's okay. You can put it in plastic bags as long as it's not for permanent storage. And then after having elicited this kind of testimony, then impeach her with the fact that her husband works for robbery, homicide, and this alleged prior inconsistent statement. I don't think that should be allowed, and it seems like it's a patent case of setting up a straw person. Because why would you call a witness to testify about policy who you don't think is telling the truth, and then have to impeach that witness on the witness stand? I mean, there are many people that can testify about policy, many of whom are far more qualified to testify about policy than Michelle Kessler, so pick someone that you think is going to tell you the truth, rather than have her testify to something, say, well, she's obviously not telling us the truth, therefore we have to impeach her. I don't think that that kind of subterfuge should be allowed by the court. And let me just say, as to this issue of collateral impeachment, Michelle Kessler does not have personal knowledge as to when the items were sent out. When she testified at the grand jury hearing, she had forgotten that she had been told previously that the item had already been sent out, and she testified that it's ready to be sent out. It's not the kind of thing that anyone would want to lie about anyway. It doesn't help the people, it doesn't help the defense, it doesn't mean anything in the context of this case. And there doesn't appear to be any material difference between having been sent out and being packaged and ready to sent out. What had happened is that the item was in fact sent out and the testing was halted. And this kind of a instance of a witness misspeaking herself on a completely collateral issue should not be allowed. So I'd respectfully submit, Your Honor, that these 5 items
I'll
that
be
I've
back,
talked
guys.
about should not be permitted in evidence. And that perhaps after they've been excluded, counsel will have nothing left to ask Ms. Kessler.
All right, thank you, counsel.
I just want to clarify one thing on the leak.
Nope.
These other issues.
Nope. I've heard enough about the leak. I've heard about the leak 4 times now.
Well, it's not about the leak. What I just want to say is that we don't intend to even call reporters. I don't think we need to. I think that just with Ms. Kessler, frankly, testifying, she already testified at the 402 hearing that she was aware of the fact it was reported in the newspapers, that same information. And it's not hearsay, because it's not being offered for the truth of the matter, sir. It's just being offered for the fact that it was in fact published in the newspapers.
All right, thank you. All right, court has dealt with this issue in a series of different guises. However, the issue is the same, whether or not this is relevant under 350 of the Evidence Code, whether or not it also involves an undue consumption of time given the very limited, almost in fact non-existent probative value. The court sustains the relevancy objection under 350 and also under 352. Having balanced this and weighed it 3 times, 4 times, perhaps 5 times previously, that ruling stands. As to the issue of Michelle Kessler's spousal relationship to a co-worker of Detectives Van Etter and Lang, counsel may inquire into that briefly. It does present an issue of potential bias. As to the Griffin hearing, the fact that Ms. Kessler gave incorrect testimony, if she in fact testifies similarly, she can be confronted with that prior inconsistent statement under oath. As to the policies and procedures of the Scientific Investigation Division, I'll allow some latitude in presentation of that testimony, since as the acting director at the time in question, as now the director of the lab, she should be familiar with the policies and procedures regarding the functioning of the SID, and that is an appropriate area of inquiry. All right, let's have the jury.
Your Honor, just one other thing. For the purposes of this examination, I would ask that the court declare her under the Evidence Code an adverse witness. I think.
Well, let's see how she answers. It's also not a civil case. All right, let's have the jury. I don't know, we may go to 5:15 just to get in a good half hour with this witness. Madam Reporter? All right. Gentlemen, please be seated. Let the record reflect we've been rejoined by all the members of our jury panel. Next witness.
Defense calls Michelle Kessler, please.
Michelle Kessler, Michele Kestler.
Mr. Neufeld.
Thank you. Good afternoon. Good afternoon, Ms.
Good
Kessler.
afternoon.
Ms. Kessler, what is your current title?
I'm employed by the City of Los Angeles Police Department as Chief Forensic Chemist.
And are you also the director of the Scientific Investigation Division Laboratory?
I'm the director of the Criminalistics Laboratory, yes.
Okay. And what was your title as of June 12, 1994?
I was the Assistant Laboratory Director, or one of the Assistant Laboratory Directors.
And could you please tell the ladies and gentlemen of the jury when your title changed?
I don't recall the exact date. I believe it was sometime in late July.
All right, so as the director of the Criminalistics Laboratory of the Los Angeles Police Department, you were Dennis Fung's boss, is that correct?
I was his ultimate superior, not immediate supervisor by any means.
And you're also the ultimate supervisor of Andrew Mazzola, is that right?
Overruled.
Ultimately,
And you're also the ultimate supervisor of Colin Yamauchi
yes,
and Gregory Matheson.
yes.
Now, as the laboratory director of the Criminalistics Laboratory of the Los Angeles Police Department, did you have day-to-day management responsibilities for the various units within that Criminalistics Laboratory?
I had overall management responsibility for the laboratory, not day-to-day responsibilities for day-to-day functions within the laboratories, no.
All right. And in that Criminalistics Laboratory, you would have management responsibilities for the Crime Scene Investigation Unit,
Ultimate management responsibility, again, not day-to-day,
and you would have ultimate management responsibility for the Serology unit,
yes,
and for the Hair and Fiber Unit,
yes,
and for the DNA Unit.
yes. Well, DNA and serology are all one unit, actually.
And how many criminalists were working for the Criminalistics Laboratory on June 12th of 1994, approximately?
Can't recall exactly. We had so many vacancies, probably about, I believe at that time we were down to about 40 staff members, but that's approximate.
And was another one of your responsibilities, Ms. Kessler, the evaluation of current programs and procedures in those units?
Ultimately, yes. Not day-to-day, again, not until they're approved all the way up through the chain.
Well, and if the procedures in a particular unit were inadequate, you would have ultimate responsibility to make improvements in those units, wouldn't you?
I would suggest and listen to my supervisors, and if I personally was an expert in the field, depending on what it was, and I thought a procedure needed to be changed, I would ask for it to be changed.
But if your deputies made recommendations to you, ultimately it would be your decision whether or not to implement those changes. Is that correct?
Most of the time they made their own changes because I don't need to be involved in every small change that's made in the division.
Well, let's talk about some of the larger changes. If you introduce a new program into the Criminalistics Laboratory, and as a result of that, new procedures need to be implemented as well, would that ultimately be a decision that you would make as the manager of the, or as the director of that laboratory?
Overruled.
Sorry, I didn't-
You can answer the question.
Thank you. Not necessarily every small detail. Not again, no. They might review them with me, and then I would agree or disagree that we should go forth with the program.
Well, for instance, how many years ago was it that the DNA unit was introduced into the SID Criminalistics Laboratory?
Overruled.
When they started operating, doing casework, or when we started beginning to attempt to implement doing DNA or researching it.
When did you actually begin the implementation?
They began actually doing casework. I can't say when the implementation began. The actual casework began in late 1993.
And if as a result of implementing this new unit, if as a result of opening this new unit at the LAPD, it was determined that new procedures were needed, and new training, for instance, was needed, would that ultimately be a decision that you, as the director, would make?
Overruled.
Again, I think we can cover this all in one answer. Again, it's not always my decision as to who gets the training. I take the advice of my subordinates who are directly responsible for that. Now, if it comes down to a let's draw straws and see who wins, oftentimes I make that tie-breaking decision.
Now, in addition to those responsibilities, Ms. Kessler, did you also take responsibility for managing or overseeing some of the larger cases?
Not overseeing or managing, just being kept abreast of what was going on in those in larger cases at times, especially when they get out of hand, in volume, that is.
Ms. Kessler, you recall testifying at a hearing in this case on June 30th, 1994.
Sustained.
Ms. Kessler, isn't it true that you also have responsibility for managing or overseeing large cases at the SID Criminalistics Laboratory?
Overruled.
I'm not clear what you're trying to ask. You asked me this once a minute ago, and I said that I often review and not directly oversee on a day-to-day basis. Again, unless there's some reason for me to jump in and take part. It's much as the chief of police oversees anything in the department. He doesn't do it personally. So you need to be more specific what you mean.
Well, was it your practice to oversee and stay involved in the large cases?
Overruled.
No, it isn't my practice to stay involved. I like to be kept abreast of any large case and occasional rundown of what's going on in the cases. I try not to get overly involved. Stay out of the people's way.
Nope, proceed.
On June 30th, when you testified in the hearing, were you the assistant laboratory director or were you the acting laboratory director or were you the assistant laboratory
I was the
director?
assistant laboratory director. at
And
that
as the
time.
assistant laboratory director was,
Talking about 1994.
yes, on June 30th, 1994. At that point in time, and by the way, were you also the assistant laboratory director on June 12th, 1994?
Yes, I was.
Okay. And at that point in time, wasn't one of your responsibilities to manage large cases?
No, I didn't manage them. I often took part in them or reviewed them, but I didn't directly manage the large cases for the most part.
Under oath, on June 30th of 1994, when you asked this question, did you give this answer? Page 18. You there? Want to read with me? Question. Tell us what that means. What are your duties? Answer.
Objection, this isn't impeachment, Your Honor.
Overruled.
Answer. My duties include the managing and overseeing of several areas there, including the serology DNA lab, the trace unit, and many of the other units that are there. Question. And what does that mean? What exactly do you mean by that? Answer. Well, managing also means evaluating and implementing programs such as serology and DNA, including evaluating crime scenes and managing task forces or large cases, and the employees that are doing the work.
Yes.
You asked those questions. Did you give those answers on June 30th?
Objection, motion to strike. That one.
Overruled.
Yes, and that's exactly what I've been telling you here. I try not to get involved. I don't do every large
Excuse
case.
me,
You
Your
asked me
Honor.
if
I just asked if she was asked
Oh,
those questions
sorry.
and
No.
gave those answers. It's
She
not
gets-
responsive. Move to
no.
strike.
She gets to answer and explain her answer.
Okay.
Proceed.
I was trying, that's exactly, what you said there is exactly what I was trying to say. I try not to get involved in every large case. You asked me if one of my duties, I thought you asked, was to manage large cases. Occasionally, I will manage a task force or a large case. And yes, I oversee the units. We talked about that.
In this particular case, did you play a role in overseeing what happened at SID?
Not all through the case, no.
Well, through part of the case, did you play a role in overseeing what happened at the SID Criminalistics Laboratory?
Along with Mr. Matheson, who was primarily in charge of overseeing the case, and then I worked with him a little bit more.
In fact, Ms. Kessler, didn't you play a larger role in the Simpson case than in other cases because of certain staffing problems with regard to Mr. Matheson being the only deputy you had?
He was the only supervisor in charge of the serology, DNA, and trace units. So yes, I played a little larger role than I usually
A
do.
larger role in this case than you usually do, that's correct?
Yes.
Okay.
And it wasn't just Mr. Matheson, it was just our lack of staffing in several areas.
Isn't it true that the reason was not because of other staffing, but because there was no other assistant laboratory director besides Mr. Matheson? Isn't that the reason?
No, Mr. Matheson wasn't the assistant lab director at that time. He was the supervisor of the serology DNA unit, and Mr. Johnson is the other assistant laboratory director.
On August 1st, 1995, were you asked this question, did you give this answer at a hearing outside the presence of the jury in this courtroom under oath?
Objection on that.
Yes.
Oh, I'm sorry. You asked this question, did you give this answer? Question. In this particular case, did you play a role in overseeing the processing and handling of the case? Answer. I was attempting to assist in that process because at that time, Mr. Matheson, there was no other assistant laboratory director, so I played a little larger role than I normally would. Did you give that answer to that question just 2 weeks ago?
2 weeks ago?
On August 1st, 1995.
No, I was referring to myself as being,
I'm sorry, Your Honor, I would move to strike. I'm asking if she gave the answer.
She's entitled to answer the question. Answer the question.
what, I said that, but I was referring to myself as the only other assistant laboratory director at the time. I don't know I don't remember what that was referring to. Is it out of context?
Next question.
Well, do you acknowledge that you gave that answer to that question just 2 weeks ago in this courtroom?
I possibly did, but I don't know what it was in reference to, but I don't know what time frame it was referring to either. Did you have a time?
Let me show you your testimony.
Thank you.
It starts here. Goes to here.
Thinking supervisor. I don't know what I was thinking of.
Ms. Kessler, did you give that answer to that question on August 1st at a hearing in this courtroom?
Apparently I did.
Okay. In fact, during the first couple of weeks after September 12th, I'm sorry, in fact, during the first couple of weeks after June 12th, 1994, didn't you participate in several meetings concerning this case?
I wouldn't say several, maybe 2 or 3, maybe 4 meetings. Not a lot. I don't recall a lot of meetings.
Well, I didn't ask you if it was a lot. I asked you if you participated in several meetings, Ms. Kessler.
It's vague as well. Sustained.
All right. Ms. Kessler, did you take any notes at the, I'm sorry, you believe that you participated in how many meetings during the first 2 weeks?
Just a few
Okay.
that I recall.
All right. In the few meetings that you recall participating in, did you take any notes?
No, I had no reason to.
Well, Ms. Kessler, didn't you say a moment ago that you did play some role in overseeing this case in your role as the assistant laboratory director?
Yes, but I was not any need to take notes. Notes were being taken by the parties involved if they were necessary. I had no reason to.
Ms. Kessler, as the assistant laboratory director, would you give certain suggestions or directives to other people?
Yes?
And would you agree that one way to know what directives you give to these other people would be to write down what you said so you could look back on it at a later time and see whether or not the person followed your directive?
Yes, if I thought at that time that I couldn't remember it myself.
Okay, but you now feel that you didn't need notes because you could remember it?
At that time, I felt I could remember anything that was going on, yes.
All right, well, let's see. When was the first meeting that you participated in connection with this case?
I didn't think that was important, so I wouldn't have written that down anyway, probably.
All right, who was present at the first meeting that you participated in connection with this case?
Again, I wouldn't have thought it was important, so I wouldn't have written it down.
Well, I'm not asking you that. Can you remember who was
No,
there?
I don't even remember when it was.
You don't remember what?
I don't even remember when it was.
Okay, so you don't remember when it was, you don't remember who was there.
No,
Do you remember, the subject matter of the very first meeting you participated in connection with this case?
no, no,
I'm sorry, no?
no.
Isn't it true that as early as 8:30 in the morning on June 13th, you would telephone, they called you at your home to tell you about this case?
Objection, Your Honor, to the leading.
Sustain.
Did you participate in a meeting on June 15th with Assistant District Attorney Marcia Clark about deciding which evidence should be sent out for testing?
I don't recall the date because I didn't take notes on that. There are notes on that meeting, but I didn't take them. I don't recall the date. We did have a meeting soon after with Marcia
Who
Clark.
took the notes at that meeting?
I believe Greg Matheson.
Did you review Mr. Matheson's notes at that meeting before coming here today?
No, I had no reason to. I didn't know why you were calling me, so.
Who else was present at that meeting on June 15th with Marcia Clark from the District Attorney's Office?
I don't recall.
Was there a discussion at that meeting regarding a decision to send evidence out for DNA RFLP testing?
Overruled.
I don't recall if there was that day or not. I know at some point we had a meeting as to what evidence we had and what was going to be tested and who was going to test it.
On the very next day, June 16th, did you participate in another meeting about this case?
I don't recall.
Do you recall being at a meeting with Aaron Riley, Colin Yamauchi, and Dennis Fung, and Greg Matheson about this case on June 16th?
Overruled.
I don't recall.
Do you recall participating in a meeting at about that time to discuss the need for security in this case?
Overruled.
Security of evidence in general, or?
Security of the evidence in this case.
Okay,
Do you
the
recall having that meeting on or about June 16th, 1994?
Objection, since facts not known.
Overruled.
No, I do not recall the meeting, but we have a security policy on evidence in general, which was followed in this case the same as it is in all cases.
I'm not asking you about the policy in general. I'm asking you, ma'am, if you recall participating in a specific meeting to address security issues concerning evidence in this case on or about June 16th, 1994.
Overruled.
No, I don't recall any meeting regarding that specific issue.
As the director of the criminalistics laboratory at the SID, wouldn't you agree that security of the evidence in this high-profile case would be a concern of yours, the director?
Overruled.
I agree that it would be a concern, but it's a concern in every case we have, and we treat all cases regarding evidence the same. Now, if the department classifies it as a confidential case, then the evidence in our property section, whether it be in our property section or somewhere else, is handled differently, but we don't declare it confidential. That's done by the Los Angeles Police Department, not us.
Ms. Kessler, but is it your testimony that there was no specific discussion about security in this case?
No, I didn't say that. I'm sorry.
Sustain.
Well, what is your recollection as to whether or not there was any meeting to discuss security issues pertaining to this case in particular with other individuals from the SID Criminalistics Laboratory?
Objection, Your Honor, answer.
Sustain.
Do you recall participating in a meeting? By the way, do you have any notes of a meeting to discuss security in your laboratory?
No, well, I don't personally know, and I don't know if there are any. I didn't review all the notebooks before I came here.
On June 21st of 1994, did you participate in a meeting with Dennis Fung, Greg Matheson, and Colin Yamauchi regarding what additional analysis should be done on the evidence in this particular case?
I don't recall that particular date and time.
Did you take
specific
any
discussion.
notes at that meeting?
No, I did not. If I was there. I don't recall the meeting, so I can't answer.
You said a moment ago that one of the reasons you didn't take notes is it was your impression at the time that you could remember what transpired if need be. Do you recall testifying to that a few minutes ago?
Yes, and I said at the time I remembered. At this point in time, I don't remember because at this point in time, it wasn't important. So, once it wasn't important anymore, I don't remember it.
If you don't remember what it is that transpired, how can you determine that it's not important, Ms. Kessler?
It's argumentative, counsel. Rephrase the question.
Okay. If you don't remember what transpired at any of these meetings that you were present at, how do you make an assessment as to whether or not what transpired at the meeting was important?
Well, first of all,
Assumes facts aren't evidence. Sustain.
Ms. Kessler, you said you did play some role, a greater role in this case than other cases, in overseeing. Is that correct?
In assisting and overseeing. Mr. Matheson, again, was the played the major role, kept the notes, and documented everything.
Would you agree, as part of that role of overseeing or assisting in the overseeing of this case, that maintaining the security of the evidence is certainly an important point?
Yes, I think we talked about this earlier.
And would you agree, Ms. Kessler, that as someone who was assisting in the overseeing of this case in that laboratory, that decisions as to whether or not the evidence should be sent out for DNA testing as opposed to being handled in-house for serological testing is another important question?
Yes, and I never said that we didn't discuss it at some point. I just don't know the date and the time and who was there and exactly when we made those decisions.
Ms. Kessler, didn't you tell this jury a little while ago that not only do you not remember who was there, when it happened, but you don't even remember what was said in substance at those meetings? Isn't that true?
Objection, Your Honor. This takes the testimony.
Sustained.
Do you have any recollection at all of the substance of the meeting regarding the security measures that needed to be taken in this particular case?
Been asked 3 or 4
Sustained.
Your Honor, perhaps this would be a good time to break for the afternoon then?
Proceed.
Okay. Was it your practice, Ms. Kessler, not to take notes in meetings that you participated in where you were involved in assisting to oversee a particular case?
You can answer the question.
It depends on what the substance of the meeting is and how much my role is in the meeting, whether I take notes or not. If I don't give any directives and I just sit back and listen, I don't always take notes.
Ms. Kessler, as you sit here today, do you know whether or not you gave any directives regarding the security that needed to be taken, security measures that needed to be taken regarding the evidence in this case?
Once the case was made confidential, I gave some directives, and those are standard directive policies within the department, so I wouldn't write that down as being specific because it's not to any one particular individual.
Ms. Kessler, what you're saying is you didn't write down then the directives that you gave in this case regarding security. Is that correct, ma'am?
No, other than I notified everyone that it was to be it's being handled as a confidential case, and confidential cases have a standard way of handling
Your Honor,
the evidence.
I would move to strike. I asked her if she wrote down the directives she gave, not what the directives were.
Answer is stricken. Jurors to disregard.
Sorry, I misunderstood what you're asking.
Certainly. Did you write down the directives that you gave regarding security measures to be taken in this case?
No, I just told the people that it was to be handled as a confidential case.
Did you write down any of the decisions that were made regarding what types of analysis should be done in this case?
Those were written on an inventory I did with a couple other individuals on, I believe, June 29th.
Did you write down any of the directives that you gave at a June 21st meeting with Dennis Fung, Greg Matheson, and Colin Yamauchi regarding what types of analyses should be performed?
Sustained.
You said a moment ago that you mentioned directives on a particular date. What was that date, ma'am?
June 29th?
And
I
how do you
believe.
remember now, on August 14th, 1995, writing down directives on June 29th?
Because I have those in writing.
Well, did you review those documents before you came to court today?
No, but I brought them with me, I believe, or I looked at them before because we talked about them in other meetings.
Are there other notes and documents that you looked at and that you brought with you today to assist you on the witness stand?
Part of my problem, counsel, is I tried to bring like my attendance records and things that you interviewed me about, so those are things I tried to review, and you didn't interview me about any of these things, so I would
Ms.
not
Kessler,
have thought to review that.
Did you bring any notes with you to assist you in your testimony today?
Well, if I have my attendance records because you wanted to know where I was on a
Ms.
particular
Kessler,
day,
please,
yes.
I'm just asking you if you brought notes. I'm not even asking you for the particular
Excuse me. Both of you stop. I'm going to quit today. I want counsel to stay on both sides. Ladies and gentlemen, we're going to take our recess for the afternoon. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Also, don't allow anybody to communicate with you with regard to the case. I'll see counsel in chamber. The Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazer, Mr. Scheck, Mr. Neufeld, people represented by Ms. Clark, and Mr. Dart. The jury is not present. The record should reflect that this morning the court held 2 in-chambers meetings with counsel, specifically with regard to an issue that has been raised by the so-called Furman tapes. And the record should reflect that although the tapes have been discussed with the court does not have a copy of the tapes, nor has the court reviewed the transcripts that are said to exist with regard to these tapes. Further, during the course of our discussions, counsel for both the prosecution and the defense have advised the court that their review of these tapes indicate that Mr. Furman apparently has made comments that are disparaging of this court's spouse, Captain Margaret York of the Los Angeles Police Department. It's further been indicated to the court that there is a possibility that the prosecution will call Captain York to testify as a witness in this matter in light of that development with regard to the credibility of Mr. Furman. Code of Civil Procedure Section 170.1 sub A sub 1 states as follows: a judge shall be, which is mandatory, shall be disqualified if the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. A judge shall be deemed to have personal knowledge within the meaning of this paragraph if the judge or the spouse of the judge is to the judge's knowledge likely to be a material witness in the proceeding. So at this point, what is necessary to determine is whether or not Captain York will be a material witness in this case, if her testimony would be relevant or material to any of the issues before the court. If that is true, then this court would be required to recuse itself from further participation in this case. All right, I'll hear from the parties. Just when you thought we couldn't have anything crazier happen.
Yes, Your Honor. This has been a most unique case in many particulars. However, Your Honor, the defense rises at this point to indicate to the court we feel this is a tempest in a teapot. Let me make very clear the defense position about these tapes, and then our position, and Mr. Simpson's position, about what should happen as to whether this matter should be sent out at all. First of all, the court is aware that the defense is the one who pursued these tapes, not the prosecution. And I think that's the first point, Your Honor. From a standpoint, this was their witness. They had an obligation to come and tell us about this witness who commits perjury and engages in 10 years of tapes over a period of time, where he's speaking in dialogue, and not only in dialogue, these are interviews with Mark Furman. We're the ones, with your help, who pursued these tapes. And to put them in perspective, what we suggest to the court is this is a ploy by the prosecution, because they don't want to proceed further. We will never agree to a mistrial in this case. This case should not be sent out. What we propose to do is to give you the tapes, which are the province of our work, submit the tapes to you with the portions regarding Captain York redacted. Those portions where Mark Furman, who doesn't seem to like anyone in those tapes, is disparaging, have nothing to do with this case. You have ruled back in January that we are entitled to impeach this man based upon his racial animus, based upon his proclivity or propensity to implicate innocent individuals, and then perhaps a third category of general credibility where he's just lied about certain things. For instance, the fact of whether or not he was going to sue Robert Shapiro. Now, we've heard all of these tapes. So I want to make the record very clear. This man is an important part of the prosecution's case. As I indicated to the court, in these tapes, Mark Furman indicates, I am the key witness in the trial of the century. If I go down, the prosecution's case goes down. It goes down, and he says, bye-bye. And that's what they're faced with, bye-bye. They see their case floating out the window because this is a critical witness in their case. And Bailey did a good job of tying it together about whether he had lied. This man has committed perjury. There's no reason to dance around this. He has committed perjury, and that's the issue. Your wife has nothing to do with that at all. They cannot rehabilitate Mark Furman if he uses the N-word 30, 40 times. Margaret York never heard him say that word, presumably. They can't rehabilitate him on that. If he talks about destroying people's driver's licenses and then arresting them, if he talks about choking out people because they're black, when he talks about how you stop a black man, and he uses the derogatory term, in a Porsche, and he gives tips for stopping individuals, when he talks about how you lie, how you back your partner up for 6 months, you lie up to 6 months, anything short of an indictment to implicate people. You just arrest them because they're black, and he doesn't use the word black. Margaret York has nothing to do with any of that. They've got to face up to this fact. This is their star witness. They vouch for him. We will prove he's a liar. They know he's a liar. They have an obligation. And it's so ironic, Your Honor, in this case, that Ms. Clark, back in chambers last week, would tell you, we're going to object to the tapes. We reminded her she hadn't heard the tapes. How was she going to object to the tapes before she heard them? Now we find out they're going to object to the tapes. It's like those socks. So we're troubled by this in this so-called pursuit for justice and honesty. And so what we're proposing is that when the tapes are brought down here this afternoon for you, that the part regarding Margaret York be redacted. There's no reason to get into this side issue. Mr. Simpson is not going to stipulate to any mistrial. Jeopardy has attached in this case. We want to go forward. We want to finish this case as soon as possible. Ms. Clark now adds to the scenario in our latest visit in chambers by saying she can't tell what's going to be material, and some other and you shouldn't tell. Some other judge should make that determination. Well, as I told the judge in North Carolina, who knows better what's material in this case than you do? You've been here since September. We don't always agree with your rulings. I mean, that's pretty clear, and I think you accept that. But you know these facts. We rely upon you. Mr. Simpson relies upon you to be fair and give him a fair trial. This jury relies upon it. All of America relies upon this. Another judge who comes in here doesn't know anything about this case at this point. as I saw in the first court in North Carolina. We had to overturn him. So we're saying that you're in the best position. Your wife has nothing to do with this. With regard to Furman rises or falls based upon his own voice, Your Honor. He's the one talking from April of 1985 to July 28, 1994. He's the one using these derogatory names. He's the one who hates women and Mexicans and black people. He's the one who hates all of the commanders. And this case is about real people. He talks about Commander Hickman. He talks about Deputy Chief Frankel. He talks about Darrell Gates. He's talking about his life as a police officer day by day. He talks about criminal conduct by himself and other police officers. This is a blockbuster. This is a bombshell. This is perhaps the biggest thing that's happened in any case in this country in this decade. And they know it. They've got to face up to it. Your wife has nothing to do with that. That's a side, minimal issue. And you should not be persuaded to send this case anywhere based upon that. Because we're not going to stipulate to any kind of a mistrial. We want to go forward. We want our day in court. And we feel most strongly about this. And this, the last thing I want to say is that this whole thing, Your Honor, needs to be unmasked of what it is. And on information and belief, I can tell this court that every file in the LAPD relating to this man, Mark Furman, has been sealed or hidden. Cases that have been settled the last 6 months, the Britain case and everything, you can't find out about them because they sealed everything. Just in the last 2 weeks, a box of files on Mark Furman in Sacramento have been hidden and secreted away. Now, these are the things of a police state, and it's wrong in America for this to be happening, to cover up for this man. Doesn't mean all police officers are bad, certainly doesn't. But when they close ranks and do this, for those people who don't believe that there's been a conspiracy of silence here, this is the ample proof. His voice will give you the proof of what he thinks a real police officer should be and how you stand up. And that's why he believes that women don't count. And so the things that have happened in this case are troubling to this community. And anybody who supports what he does doesn't deserve to be an officer of this court. And so what we're saying is that let's get it out there. Let's lay it out. This is a search for truth. We're not going to hide this anymore. This court should hear it. This jury should hear it. All of America should hear it. And when they do, they'll understand what the defense has been trying to say for all these many months. And so I ask you, with all the fervor of my being on behalf of my client, as we've asked you before, don't send this case. Don't stop these proceedings. You saw our jury. We promised these jurors, Judge, this case would be over in April. It's now August. We're trying to do our part. They took 6 months. We're going to take less than 6 weeks. We want to finish this case. We've only got a few witnesses left, including this thing on Mark Furman. I told you Ms. McKinney is in town. We're ready to call her as early as tomorrow. We're ready to proceed. We want to put the people on notice. We want Mark Furman brought back from Idaho. We'll give them notice right now. We want to finish this case with this jury. You saw them yesterday visibly upset with the cross-examination, and it's time to bring this matter to a halt, not engage in these shenanigans again of sending it out to some other judge who knows nothing about the case. He's going to listen to all these tapes after all this, these hours and hours of tapes? He or she won't know the facts. You know the facts. So isn't our decision, or our proposal, to redact the portion for Margaret York, isn't that the relevant portion? You've ruled many times against us on this 352 argument. Well, if ever there's a 352 argument of somebody being irrelevant, it's going to be Margaret York, because you can see, what does she have to do with anything? There's nothing to do with that. We're the proponent of the evidence. We're not going to bring her in. They're grabbing at straws when they say they may bring her. And I guarantee you, that when this is all said and done, they're going to call your wife in here. They're not going to do it. This is just a ploy. We want to proceed with this trial and get it over with. And we ask you respectfully to do that, to listen to us. We think we're right on this. And this is a matter, I need hardly remind you, this matter has cost the county of Los Angeles some $6 million. And I think that Mr. Simpson hopefully can get a fair trial and get a verdict that reflects the evidence. And it's too late for them to turn back now. They should have thought about this in that rush to judgment back on June 13th, 1994. But now it's too late. They should have thought about this when they put Mark Furman on the stand. And now it's too late. And we're going to hold their feet to the fire. And no matter where, if the case is sent out, we're going to resist it. We're ultimately going to get back here. This court, this jury, this country is going to hear these tapes. There is no hiding. They can run, but they can't hide. If the court has any questions, I'll be glad to try to answer them.
Yes, Mr. Cochran, I take it the problem is what you're asking for me to do, though, is to make a ruling on whether or not my own wife is a material or relevant witness.
No, let me correct the court on that. I'm not asking you to make that ruling at this point. What I'm asking you to do, we're the proponent of the evidence. What I'm asking you to do is to receive a redacted version of the tapes. The issue you have to make is whether or not these, what he says is material. When he calls somebody the N-word, Judge, and it's in the last 10 years, and it's his voice, and he's speaking about how he feels about black people. When he says, I mean, it's so derogatory, I don't even want to repeat the things.
Right,
when he says those things, that's the issue, Judge. And so, and the racial animus, it fits within your order. It has nothing to do with your wife.
So, Mr. Cochran, I have to accept, don't I, the offer of proof by counsel, by Ms. Clark, that they wish to offer their testimony. I have to accept what they offer.
No, you don't. I'll tell you why not. Because as you've done so many times, Your Honor, this 352, where is the relevance of it?
No, but even the determination of whether or not the offer of proof is sufficient, I don't think this court should be the court to
Bear
make
with
the
me just one
determination.
second. Give me just a
Sure.
second. reminded by my learned colleagues that we just left chambers, and I mentioned this earlier. Ms. Clark says she can't even argue materiality until some judge passes on the issue of what the jury is going to hear, and that's exactly the point. You never get to this. We're the proponent of the evidence. You don't even get to Margaret York. When you rule on his use repeatedly of the N-word, when you rule upon all the times he lies, and there's an example on the judge about finding a gun, and you lie and you say you saw a suspect through it, because you know he's probably guilty anyway. You know, that's exactly on point, what we're talking about in this case. Or tearing up a black man's license, saying he has no identification. That's exactly on point. Those things have nothing to do with Margaret York. And so she herself said, you said, she wants a judge for all purposes. A new judge to come in here or go someplace and rule on the materiality of not only Margaret York, but all of this. And that's preposterous. That's a new position they've carved out when they went upstairs, isn't it? It is. And so what I'm saying, you don't get to that point. Your ruling back in January is the law of the case in that regard, about the things we can do. Now, we may seek to expand it just a little bit by virtue of the fact where he has lied about other things that we can now prove by his word, but that fits within the whole rubric of credibility, which this is all about. I mean, so we're clear about this. And for those people who want to run around talking about race card, it's not any race card. This is about credibility card. This is about perjury. That's what this is about. People should understand that. So we're not asking you to do that. And I am very sensitive, Your Honor, to the fact that your wife's a police officer. We've been sensitive about that since day one. We're very sensitive. But we have relied upon you to be fair despite that. We knew about that first day, did we not? They knew about that first day. We relied upon your integrity. And Mr. Simpson chooses to still rely upon that integrity. What he is saying is that this is not an issue. It is a non-issue being drummed up by them. You never even get to that. Who in the world could pass upon materiality, which he now talks about, but you? You think one of your colleagues can pass upon materiality in this case? I don't think so. And so that's the issue based upon her new position. That it doesn't make any sense. So when we submit these things to you, you will then see for yourself without Margaret York. And then you will see how, under no scenario, could they call Margaret York to the stand. Now, we have furthermore, let me tell you how ridiculous they are. I'm going to show you something, Your Honor. How ridiculous this is. Early on, when we sent this matter out to another court, and I'll just speak briefly about this because I don't want to infringe upon any conflict right here. Your wife was kind enough to do a declaration. And in that declaration, let me just read you just one paragraph so you'll get a sense of how they're not going to be able to call Margaret York. Paragraph 4, this is a declaration of November 21st, 1994. I possess no relevant material or personal knowledge of Officer Furman, nor do I possess any information relevant to this case. Now, that's what your wife said under oath in that declaration of November 21st, 1994. You know, it's grabbing at straws to think now that they're going to call her up there, they're going to impeach her, they're going to impeach her based upon this. I mean, they just can't create stuff like this to try to get a mistrial and throw somebody off where we're on our way. They can't do that, Your Honor, and so that's the point. And
let me just make a comment. I think that when I was contemplating these issues last night, I was concerned that if I had to recuse myself mid-trial, that would be legal grounds for a mistrial, even over Mr. Simpson's objection. And my legal eagles from my law clerk staff found me People versus Espinosa, which is at 3 Cal 4th 806. It's a relatively recent case written by Justice Kennard and concurred in by all the remaining justices, that in this situation the trial judge became gravely ill and a second judge had to step in and take over the trial. This was a death penalty case which did in fact result in the death penalty. And the judge was placed midway through the guilt phase. And the court found that there was a legal necessity for the change of judges. However, that in that situation another judge could then step in and take over the case. If I'm required to recuse myself under 170.1A1, I am convinced that the case law would support another judge stepping in, unfortunately having to take a week to read the transcripts or watch the video.
They will be, Your Honor.
But I don't think I see mistrial as a consequence.
Well, then let me just say this. If there is a mistrial, we believe jeopardy is attached. So if that's what they're hoping for, it's not going to work. We never agreed to it anyway at this point. And we told you back in chambers that we thought that was possible. We know of a case in Las Vegas, as Mr. Shapiro indicated to you, where a judge is indicted during the trial and they bring another judge in, or if someone dies. So another judge could do that. But even if another judge does that, you see, the problem still is, we have an obligation to these citizens over here who've been sitting in this case. We promised to get them out of here. We have an obligation to move this case forward. And I just think who, among your brethren and sisters on the bench, is going to be able to determine materiality or relevancy better than you are, after having been on this case for well over a year now, if the part regarding Captain York is redacted. And that's the point that I'm indicating, because I've tried to indicate to you as clearly as I can, there is no basis for calling her. You know, you heard a number of times our argument regarding something we felt very strongly about, the ability to call these reporters, and something we felt very strongly. And repeatedly, you rule, it's not relevant, it's not relevant, it's not relevant. I'm telling you, that's not even close. This is not even close to that. It's like night and day. And they're grabbing at straws. And I think you can see from what I've told you. How could Margaret York, based upon your earlier ruling, be relevant in this situation? It's not. So that's just something they brought up, and I just think it's preposterous for us to spend all this time on it. Excuse me one second. The final thing I'll say, Your Honor, thank you for allowing us this time, is that in Ms. Clark's last discussion in chambers, she talked about somebody deciding the overall materiality, perhaps other than you. And we do take great exception to that. I don't think anyone else could do that. I think we just delay the trial unnecessarily. It doesn't make any sense. As regards Margaret York, if one makes a determination of materiality, or if you feel the need out of appearance's sake, without stopping these proceedings, someone I presume some judge could read your reading, take your ruling, look at it all, and make that judgment that I think they'll of necessity come to, that Margaret York is irrelevant material. But that way we don't lose, the trial isn't stopped, we don't lose this time, and we don't have the necessary problem. We want a verdict in this case with this jury. Make that clear. We'll be pleased if Your Honor is still here. Be with us on that date. If Your Honor can't be here under Espinosa, bring us somebody else. We want justice. We want it now. It's our client who's been in custody since June 17th, and he's maintained his innocence from that day. And now we can establish that innocence through their lying witness. And they should have known about it. And we found it. And now everybody wants these tapes. That's what we're talking about here.
Thank you, counsel. Ms. Clark.
Not no amount of inflammatory invective, rhetoric, and the persistent press conferences the counsel insists on giving in court can obscure the fact that they want this issue to remain in this court for a very cynical, cunning reason that I do not think is true, but is the problem here. And the problem is this. Given the set of circumstances that we have, the court is aware that there are allegations made. The court is aware of the fact of the statements made by Detective Furman concerning Captain York. The court is not aware of the details. But the mere awareness of that fact creates an appearance that the court may in some way be influenced in one way or another concerning the issues regarding the admissibility of the tapes. That's the legal issue that's framed. The people of this state have the right to expect that we will seek to protect the record in every way possible, regardless of what the fact of the matter is. We know that this court can be very impartial and very unbiased, and yet we cannot possibly say it would be fair to require this court to set aside its knowledge of the fact that some inflammatory statements were made about the court's spouse in ruling on an issue of this delicacy and sensitivity. The truth of the matter is that I think that what the defense wants to do here is hold this issue over the court's head, and the waiver issue as well over the court's head, hope that the court will be inflamed enough by the mere knowledge of the fact of the allegations to either rule that the tapes come in more than it ordinarily would, or bend over backward in favor of the defense to show how fair it can be, or bend over backwards to take revenge against Mark Furman. I think that's the defense thinking here. I really do. And whether it's true or not, that kind of thinking is what the courts have talked about in terms of the appearance. No matter what you do. No matter what you do, Judge, you will be criticized because there is an appearance created, and it's a no-win situation.
Well, that's pretty much par for every day, isn't it?
Yes, I agree. I mean, and I think that may be true for quite a few of us here. And the court has my sympathy in this very unusual and difficult situation. But it is not a situation that is made easier on this court or made more appropriate by counsel's rhetoric and the constant pointing of fingers and the constant allegations of lying witnesses. Now, I think it's very interesting that counsel has repeatedly said they don't want a mistrial. The people have made it clear. We want this jury to decide this case as well. In whatever manner we can, we don't want a mistrial. I don't want there to be any mistake about that, because the families of these victims have had their lives on hold for long enough. We hear about Mr. Simpson and his rights. I never speak in derogation of any defendant's rights, and I will certainly not do so here. He has the right to a fair trial, and a speedy one, and I agree. So do the families of the victims. They have rights here, they have feelings, they have suffered, they have grieved, and now they're being put through this trial on national television to grieve publicly, when at least most families of victims can grieve in their private homes. They have had to be exposed on national television with every horrible issue, every single argument, every single thing that comes up with every witness they've had to suffer through it. The court has seen them here. They have a right to have this jury hear this case and have it resolved. Now, we, in all fairness, counsel keeps talking about who got the tapes. Of court is aware of the fact that as soon as the people were aware of those tapes' existence, and that was very recent, we sought to get the tapes. We sought the guidance of the court. We asked to issue an SDT.
I recollect Mr. Darden's
Yeah.
1054.7.
So I just want there to be no mistake on the record that Mr. Cochran, once again, is trying to mislead everyone in saying that we tried to hide the tapes, that we had knowledge of them. No, we were out there looking for them first, the minute we found out. So I just want the record to be very clear about that. Mark Furman's characterization of his role in this case, whatever that may be, is so irrelevant as to be laughable. Whatever he thinks, however important he thinks he is, we all have a sense of importance about ourselves. Some of us are a little bit too low, some of us are a little too high. Doesn't matter. The bottom line is, what is his role really, not what he thinks it is. And counsel knows that. Counsel also knows very, very well, as this court does, that we didn't need to call Mark Furman at all as a witness in this case. We did. Complete the picture, we call all the relevant witnesses, whether they are absolutely legally necessary or not. Now, the fact that he was called to testify does not mean that we characterize him as being the key witness in the case. He found a piece of evidence. What we vouch for, in terms of Detective Furman, in terms of everyone in this case, is that no one planted any evidence at any time. There has been no false statement made about where that evidence was found, the analysis of the evidence, or its results. And the defense wants to squirm away from that fact by playing the race card. We don't want to do that. We've never wanted to do that. We know what a search for the truth means, Your Honor. We know that the truth we are searching for is who murdered these people, not who is Detective Furman. If there was any opportunity for anyone to plant that evidence, to plant that glove, it would be a different story, a totally different story, but there wasn't. The defense knows that. And they're caught between a rock and a hard place, because no matter how badly they want to paint somebody to be the villain in this case, other than their client, the truth of the matter is all of the arrows point to the defendant, because that's the mountain of evidence that exists that he cannot get away from. There was no opportunity for Mark Furman to plant the glove. And so whatever his personal beliefs may be, which we may or may not know, the truth of the matter is he could not do what they're trying to prove he did. And now that the evidence has come out conclusively, irrefutably, and consistently that there was no opportunity to plant a glove, they are just going all out to smear Mark Furman in the very cynical and shrewd effort to pull this jury away from the evidence, to manipulate them, to play them like fiddles, and to say, ignore the evidence. We know we haven't proven anything to you. We know we have failed to prove a conspiracy. We know that we can never prove anybody planted the glove, or the blood on the socks, or the blood on the gate. We know there are pictures of the defendant wearing the gloves of the exact same type and model purchased by Nicole just 3 weeks after the purchase that are the exact same type and model as these crime scene gloves. Don't look at that. Don't look at that. We have a big bad boy for you here who said terrible things and possibly done terrible things. That's what's important here. It would be if he could have done anything to impact the evidence in this case, but he could not. And that's the truth of the matter. And they want to manipulate this jury so that they will not look at that evidence, so they will look at only the villainous accusations made against Detective Furman, and if they're true, then it is very bad. And that is another search for the truth. The truth we are searching for here, right now, in this case, and I agree, Your Honor, let's try the Simpson case, is who killed these people. And we know it wasn't Detective Furman. Whatever Detective Furman has done in his past is not part of this case, because he could not do, and we know it now, and they know it too, he could not do what they wanted to prove he could do. So that's fine. We can all search for that truth after the fact.
All right, well, let's circle back to the issue that's presented to the court, however. You've indicated that you feel somehow that Captain York will be a material witness in this case. So isn't that a preliminary fact or preliminary legal determination that has to be made at this point?
Well, no, see, and that's the problem here, is that we need to make something, we need to find out what is going to be admissible before we will know how to respond. It would appear, based on what I've seen in these transcripts, and I've read them all, that it could very well be that Captain York will be a rebuttal witness depending on what is deemed admissible. If a court rules that none of these tapes are admissible, then obviously she's not needed as a rebuttal witness. If the court, on the other hand, rules that much of these tapes, with their inflammatory language, is played in front of this jury, and make no mistake about it, you know, if you have any doubt that what this defense wants to do is inflame the passions of the jury and cause them to look away from the evidence, you only need to refer to Mr. Cochran's remarks when he said to you just today that the remarks are so derogatory he doesn't want to repeat them. I agree with him. I don't want to repeat them either. And I don't want to repeat them in front of this jury either, where they have no relevance.
I don't want to repeat
But until
them
we know
either.
that, how do we know how we're going to respond?
Then let me ask you this question. Who should make that determination and why?
I believe that in context, knowing that what we do, I mean, the court is already aware that there are negative comments made by Detective Furman about the court spouse. I think that that knowledge requires that another judicial officer determine what is material, what is relevant, what is admissible in terms of these tapes. At that time, we'll be able to determine what the people's response will be, or potential response will be. But until that determination is made, and I think we can't know. Now, but what I was starting to address to the court was the issue of the appearances. And the sections and the brief that I have a draft of but has not been finalized yet frames that issue very squarely. And that is when there's even an appearance that there might be an impropriety or there might be a bias, then it would be appropriate for it to be referred out to another judge. Now, that doesn't mean, and in my opinion, that is a limited thing. That would mean that another judge makes the materiality call, but then we can come back.
But I just want to suggest to you that as a practical matter, I'm wrestling between the offer made by Mr. Cochran that this court make the admissibility determination of all the materials with the exception of what refers to my wife, that being redacted, versus, and then because this court is obviously more familiar with the issues and the facts and events of this case, as a practical matter, since you raised the appearances problem, and I agree that's a very wide penumbra that comes with that, and I'm very sensitive to that, as I must be. As a practical matter, it's going to take another judge who will have to read Furman's transcripts, will have to make reference to other issues in the, will have to read other witnesses. For example, Detective Lang's testimony regarding his then going outside and seeing the glove as he was directed by Detective Furman. He or she will have to read Cato Kalin's testimony regarding the conduct of Detective Furman. I suspect a Lexis word search through the transcript where Detective Furman comes up will likely involve, perhaps, my guess is that another judicial officer working full-time all day, every day will take a week to resolve this issue.
That may well be, Your Honor. The problem is, though, that I really don't see how it could be, it just does not seem appropriate under the wide berth of the appearance of impropriety standard for this court to resolve that issue, knowing what is hanging out there in terms of Captain York and the possibility of her being a material witness, and the allegations that the court has the knowledge of the fact of, if not the details. And I cannot see how it could possibly be appropriate, although I understand we have a problem with another judge having to spend considerable time to get up to speed. It can be done. And I think that in all fairness to all parties, and especially to this court, it would be a matter best left to the auspices of another court where there can be no allegation that there is any motive to do anything, either to bend over backwards to preclude the tapes or to bend over backwards to admit more of them. It is really a no-win position for this court, and I think that it is not one that was contemplated as for any court to undertake. And that is why they have the broad standard of the appearance of impropriety as it is.
Let's assume that I accept your argument concerning the breadth of the appearance problem. Are you prepared to, on behalf, or you might want to contemplate this, are you prepared to go forward with other witnesses?
I think that we could. I don't see why not, and I'd really prefer to do that, Your Honor, rather than lose time with this jury and let another judge get up to speed on those issues. But I don't see why this court could not continue to hear the rest of the case, and that would be a much more effective use of time.
All right, do you have any other comment? Any other suggestions as to what we have to do?
May I have a moment?
I suggest the prosecution go to hell.
All right, let me see counsel without the reporter, please. Additional citations of the court?
Yes, I do, Your Honor. Let me cite to the court Flyer versus Superior Court, 23 Calat 4th, 165 at page 170, and indicates that it goes into 170.1c, or excuse me, I think it's C. A6C. A6C. Quote, the standard for disqualification provided for in subdivision A6C of section 170.1 is fundamentally an objective one. If a reasonable member of the public at large, aware of all the facts, would fairly entertain doubts concerning the judge's impartiality, disqualification is mandated. The existence of actual bias is not required. And that's basically the situation that we're confronting here today. What the court is aware of is that nothing in this case has ever been kept under wraps, no matter how diligently we have attempted to do so. And in this particular case, we have parties that are not before this court that are in possession of much of this information who may have a real interest in putting out little snippets of information to tweak the interest of the public. The allegations made by Mark Furman concerning female officers and Captain York will undoubtedly become a matter of public knowledge. I have never been surprised in this case since, I guess, September or October at all the things that do come out, whether they should or not. This will, I'm sure, be no exception in either large or small part. That's the only thing we don't know is how much will come out. But we have the additional issue here of the fact of a detective on whose credibility the court will rule in terms of the evidence that will be admissible, who has made allegations about other female officers in addition to Captain York. So we're talking about an awful lot here that can be, at least to the public at large, something that would cause them to entertain doubts concerning the impartiality. And I think that under the circumstance, Judge, how can you possibly avoid criticism no matter what you do? And I realize that the court has been in that situation before, but I think in all fairness that this is one that is unfair to put on the shoulders of this court simply because of the fact that there will be nothing that you can do. And the materiality issue, well, with respect to what is admissible, we can't put the cart before the horse. So I know that another judge will be hard-pressed to go through everything, and yet
a tremendous burden on some other court.
it is. I can't deny that, Judge, but I think it's something that we have to do. We know that there will be no mistrial. We are aware of that. We went upstairs, we researched the issue, and we realized that there is no danger of that. And so that was never a concern, and had it been, we would have had to confront something else, but fortunately, we don't.
All right, just for the record,
there is another
I'm sorry.
option.
I just wanted to mention that the language that you cited to me in the Flyer case actually quotes the United Farm Workers. It's a quote from the United Farm Workers case that I cited to you.
Right, and we have that one as well, Your Honor. So
Right.
it's obviously a well-known, well-read passage. But there is another way to resolve this. If the defense wants to withdraw the race card, we have no problem and no issue. Because that is not an appropriate thing to have been injected into this trial, and it has been repeatedly by counsel. If we could just try this case on the evidence and the facts, we wouldn't be confronting this right now. This is something that has been injected into this case in a very shrewd manner by the defense. And if they want to withdraw that now and finally try this case with this evidence and these facts, we can obviate the need for all of this.
All right. Thank you, counsel. Mr. Cochran, I'm concerned about the appearance argument that Ms. Clark makes.
May I address that?
And I'm concerned, it concerns me because of...
Josh, you're 100% right. Now, any criminal, all they have to do is just say shitty things about his wife. And then, boom, no judge. And then they could just do it to the next judge, and the next judge, and the next judge.
The argument that this court, in making a ruling on the overall materiality of the tapes, might be motivated to punish Detective Furman for saying these things about the court's wife, therefore giving a broader range of admissibility. Or it could be argued in the converse that the court might not want this kind of stuff to come out and would not want the court's wife to be embarrassed or to be put through the public spectacle of being part of this trial. I mean, that could cut either way, and the problem is it's not that any of that is true. And you know, as professionals in this field, we know that things are said about people all the time that are not accurate, not kind, and oftentimes disparaging. And I know that women who operate within male-dominated professions and who are successful are always targets for this kind of treatment. And it's something that you live with and you adjust to and you overcome. But the problem is the appearance is what concerns me.
I appreciate that, Your Honor. I appreciate that very much, and I welcome the opportunity, I will not be long, to address those issues that you've raised and a couple of others. With regard to this idea of appearance, Your Honor, you've been married to Captain York for a number of years before this case. Some of us, at the outset of this case, remember back in Department 100, believed that you could be fair despite that you had integrity. Each step along the way, as I recall, you have told us when your wife was transferred, she was in bunco forgery, I think, and then she was transferred to internal affairs, and we may have concerns about her being in internal affairs, but we didn't have concerns about your integrity and your fundamental fairness in this case. As I pointed out before on this idea of appearance, the people are somewhat hoisted by their own petard. On the one hand, they want to have it sent out to determine the things on Margaret York. On the other hand, they say, well, now we want somebody to determine all the materiality. And that doesn't make any sense, because you don't have a conflict regarding all the other materiality, it seems to me, so that at least you should make that determination. I didn't hear a good answer from Ms. Clark regarding that. You would be in a position to best make that determination. Judge, let me just tell you, Mr. Blazer was kind enough to run on his computer. Mark Furman's name has been mentioned 1,813 times in the transcripts in this case. You don't think he's key to this case? It's not only in his mind, it's in their mind, it's in everybody's mind. He's key. They want to wipe him away, of course. They didn't call Dr. Golan. They can wipe people away, but they're not going to be able to do that. And so the judge, the point is, this is critical. You can't just read Lang's 9 days of testimony, another judge, and get up to speed. You've got to understand what Lang and Van Adder and Cato Kalin said. You got to understand, Judge, how important this witness is, because remember, they talk about not planning stuff. Preposterous. This man goes off by himself for 15 minutes or more, and then he supposedly finds his glove. Judge, this is after he's been taken off the case. It's not his case anymore. So, you know, I'm not going to argue that, because that's preposterous what she was saying. And a jury will make that determination. But this man, you have to get all of the facts to understand Furman's involvement. And so, you know, the thought that some other judge is going to decide materiality based upon the ruling you made back in January is preposterous. And it's unfair to the whole system. And furthermore, you know, there's another punishment I thought about when I was sitting there. This jury is going to think the defense is holding this up. And again, it's the prosecution by this frivolous attempt here, by trying to stop the proceeding. This is during our case, not during their case, because they want to avoid what's coming. Now, let me just address a couple other things, Your Honor. Counsel talks a lot about, she made a number of statements, which I won't even bother to dignify. With regard to these tapes, I should point out to Your Honor that they may have talked to Your Honor in chambers, but they didn't go to North Carolina. They didn't do any of that. We're the ones who did that, and he's their witness. So I mean, let's make the record completely clear. She talks a lot about this idea of a race card, and we take personal umbrage to that, because as this court knows, credibility is the key of every case. Calgic 2.21, et cetera, says, a witness materially false in one part can be distrusted in others, unless the greater probability of truth lies in their testimony. So, Judge, this is about credibility. It's not about race. I happen to be black. He happens to be black. These men happen to be white. What difference does that make? We're all still Americans. The question is, in this case, credibility and whether or not this man is lied under oath, which the tapes will show that he has. So she talks about withdrawing the race card. That's preposterous. You know, withdrawing anything. She'd like for us to do that. We're not withdrawing the credibility card, because that's what this is. And so that was a nice move, but it's not going to work. And now, in addition to that, Your Honor, let me come back and end on this note about Captain York. It seems to me that a reasonable and a wise way out of this is for us to continue with this case. Defense, Mr. Simpson shouldn't be punished because they have this frivolous motion. Another judge is going to take, I think you're being very kind. A week is going to be very long. You know, most courts, unfortunately, don't work as hard as we work in this court. So it's going to take a judge from 9 o'clock in the morning until 9 o'clock at night, longer than a week, to read all this testimony, to understand what this case is about, to become familiar. When you could rule on materiality, because we're going to submit to you tapes that have nothing to do with your wife. If at all. She's talking about this coming up in rebuttal, because that's the only time they get back up. So how do we even get to that issue? Because it's going to become very clear to everybody that that's never going to be an issue. Your wife has nothing relevant to say. Are they going to say, Judge, let's think about this for a minute. Is Marsha Clark going to have the gall, after we play these tapes for this jury, to stand up before this jury and say, well, he didn't use the N-word. He didn't talk about throwing people downstairs and breaking their necks. He didn't do all that stuff. And Margaret York can tell us. That's preposterous. That is preposterous. It's not going to happen. You know it's not going to happen. And so out of an appearance, because you want to be fair, but you know what? Let me tell you something. When you get in the kitchen, you stand the heat. You've said that before. You stand the heat every day. It's not going to be popular. We're mad at you one day. They're mad at you one day. Somebody's always mad at you. And so you understand that. But we handle it with respect, and we come back the next day.
Well, I must be doing a pretty good job.
Yeah, somebody's always mad at you. Well, that's for sure. And the question is, are you even-handed when you pass out these things? We talked about that yesterday, and are you even-handed? That's all we've ever asked for. We just want you to be fair to both sides. And you're in a best position to be fair on this issue of materiality. Another judge, it's an unfair burden, and they just can't do it. So we don't even get to this point about rebuttal until that point. And Ms. Clark does admit, let's go on with the trial. But the problem with going on with the trial, Judge, as you recall, we give them our witnesses, and we have, as you know, we'd like very much to finish Ms. Kessler, and then we have Mr. Regal, and then we're right up against McKinney and our ability to play these tapes. And that's what we want to do. We want to proceed with our cross-examination at that point. And I'm telling you that when the part we submit to you will have nothing to do with Captain York. We don't want to play anything about Captain York. This is our case. What do you always say? We have a right to try our case the way we want to. Now, if they want to deal in some fantasy land and try to figure a way to bring your wife in, it'll become clear not only to you, to this jury, but everybody in America that that's just folly. And it's not going to happen, I'm telling you. So why do we have to go through this in the first place? So when you get back to the idea of appearance, it has to make some sense of an appearance. The only reason you know about your wife being in these tapes, do you know why? Because yesterday Ms. Clark went up there and told you about that. We didn't tell you about that. They told you. She brought it up, and then we confirmed certain things, but she was the one who asked to tell you about that. Now, I don't think that's relevant, because we had made a decision among the defense that it wasn't relevant. We are going to offer it, so why would we even be going into that? It has no relevance. And that's the point. That's where we stand now. We have no relevance. So we find ourselves in this unique position where the defense is saying to a judge who's married to an LAPD captain, you go forward because we think you can be fair in this particular. We think even more than that, you've shown with regard to your ruling in this case, which is somewhat the law of the case. And when you look at that ruling, it's pretty clear about the things we'll be allowed to do. This is not a big issue. You know, they've tried 402 motions on every witness we had in their search for truth. But the law is already set out pretty much on what we can do with Furman, and that's why these tapes are so very, very important, because it's spelled out. It's right. I mean, Judge, if you were a lawyer and you went to sleep and you dreamed about something happening and you woke up, you couldn't have asked for more than to have the key prosecution witness on tape for 10 years talking about the things this man talks about. And when I talk about that, it has nothing to do with your wife. I mean, as I said, he doesn't like anybody. But specifically, he doesn't like black people. And but specifically, he likes to frame people. And specifically, he lies when it suits his fancy. And he was their witness, and this is about credibility, and you can't wipe out credibility, because that's the key to this case for everybody, is whom are you going to believe? It's not Miss Clark's theories. She throws out all these theories about gloves. That's just for the press. They can't prove anything about any gloves. They can't prove anything. They would have proved them before. It's just speculation. And at the end of this case, Judge, and things haven't gone well, and they're trying to figure a way out, but they're not going to get out, because you know what the facts are. And I'm just saying on this whole idea of appearance that I think you'll be fair. I don't think you're going to bend over backwards either way. I mean, I think you're going to call it the way you see it. I mean, I would expect nothing less of you. Otherwise, we wouldn't have been here in the first place. We'd have gone someplace else. So we want to finish this case with you, but we want to finish this case regardless, with or without you, as I said before, and we hope it's with you. But just remember the burden they ask you to place upon one of your colleagues for no good reason. 1,813 times Furman's name is mentioned to this point. Think somebody's going to get a flavor for that? From reading the testimony, think they're going to get a flavor for Bailey's cross-examination, how important this is? And then way off in the distance is the specter that, gee, we may think of a reason to call Margaret York so we can get you off the case or get some other judge down here. Why would they be doing that? They worried about you all of a sudden? Your appearance? Well, we're saying there is no appearance regarding the materiality, the overall materiality in this case. That the only appearance is that you're the one best suited to do it. That's the appearance we're faced with. And as to the other, if it comes up at that time and you feel some question about it, then deal with it back then. Deal with it on the back end when we get to that point. But I think after you rule on what's relevant, and we're not asking for Margaret York, and it's not their case to ask for it, so it's in our ballpark, we don't even cross that bridge. How many times do you tell us, counsel, you're premature? They are premature at this point, and it will probably never, ever come up. So I respectfully ask you to, let's go on with this case. The jury has a right to hear these witnesses and the right to get this case and make a decision. May I have a second, Your Honor? Two things, and I'll conclude, Your Honor. I think that the court has already, in fact, reviewed certain internal affairs files on Furman, I believe. I'm pretty sure about that. I know you conducted a hearing regarding the district attorney's office and their prep session of Furman, where they're all present. They sat around in the grand jury room. So you've done those things. I mean, there's so many things that you've done already. Where nobody's worried about any appearance of conflict at that point. Your wife at that point was, I think, assigned to internal affairs. We didn't raise any issue at that point because we trusted you, Judge, all along. I don't know where their trust went along the way. All of a sudden, they're worried about some appearance, and the appearance doesn't even show up at this point. Mr. Simpson, if the court would allow me, wants this court to be aware of the fact that certainly he, along with all of us in this courtroom, his heart goes out to the families and the victims of this case. He is also a victim in this case. And so when Marcia Clark makes those statements, don't for 1 minute misunderstand our sensitivities. And we try to conduct ourselves in a way throughout regarding the families of these victims. But we have a man who from the very beginning has maintained his innocence. And he is troubled by what the so-called authorities have done to hide and cover up for this Detective Furman. Somebody out there, Judge, should do something about this cover-up. Somebody should do something about all these files that have been hidden and sealed. This is still America, and that's unfair. And we think it bears directly upon Furman's activities in this case, other cases, and it has a direct bearing on O.J. Simpson's innocence. And he has maintained and continues and will maintain his innocence till the day he dies, because he believes that the facts will show that, and in fact, he is innocent. He wanted me to indicate that to the court, that there's not any lack of sensitivity at all on our part at all. But he, too, has become a victim in this rush to judgment. And so he wants his day in court, and we want to proceed and do that. Thank you very much, Your Honor.
Thank you, counsel. Briefly.
We hear no cases cited by counsel. Counsel cites to a frivolous motion. It's his motion. It is counsel's desire to get these tapes before the jury, and I agree, it's frivolous. There is no cover-up going on, Your Honor. We're not, Mr. Cochran cannot presume to think for the prosecution. He can't get into our minds or our offices or our briefcases and tell us who we can call on rebuttal and who would be appropriate. And, I think that we know how to try our case a little better than he does. And what is the appropriate witness to call in response to whatever they may be permitted to do is something that we have to determine. And this is something that we will determine only after we know what is relevant and admissible. But what Mr. Cochran is very insensitive to is the position that this court is put in and the appearances that are going to be created if this issue is left in this court at this time. The rules of judicial conduct also require that the court always remove from itself from any possibility of an appearance of partiality or impropriety. And now Mr. Cochran is trying to lure this court into abandoning that code of judicial ethics. This court knows what the reality is, and the fact of the matter is that's why the cases talk about the appearances and not the actual proof of such a thing. Mr. Cochran and his team, I am sure, are hoping and calculating that you will be biased, Your Honor. That's the point of this kind of situation. Whether you actually ever do that, and we do not believe that you will, but whether you actually do at some point or not, that is their hope and their desire. That is the motive here. That's the target. Let's make no mistake about it. And whatever you do, however you rule, there will always be the appearance that somehow they got their way, perhaps. Or that perhaps the opposite. You leaned unfairly on them to avoid that appearance. No one will ever know, because that appearance does exist. That's the problem that we face with this situation. They have the opportunity to obviate the whole thing, but they've made it very, very clear the way they want to try this case. They've been doing it now for almost 9 months. They're not going to stop. It's going to be up to a court to stop them. The press conferences, the invective, the allegations, the untrue allegations. I wasn't talking theories when I said nothing was planted. I'm talking fact. I'm talking evidence. I'm talking what witnesses have said under oath. They've got nothing of the kind on their side. They have allegations, they have empty theories, they have conflicted theories, contradictions within their own theories. It's nonsense, smoke and mirrors. Again, we're used to it. We're old hands at this. We've seen this for how long? 20 years now? The defense always gets up and puts on this smoke screen like an octopus. You get too close. Out comes the ink. This is their ink. This is it. I'm not saying that Mark Furman should be painted as a god or a hero, but he's certainly no critical witness, as counsel keeps insisting. And whatever is determined, I hope that this jury, and I have faith that this jury, is not going to be as easily played as counsel anticipates or as counsel plans. Nevertheless, counsel has failed to give this court any case authority or any factual authority or made any offer to stipulate in any way, shape, or form or issue a waiver that might make it possible for this court to hear this issue. And in light of that fact, Your Honor, we are left with the problem that we are left with. And I don't see how the court can do otherwise than have the case sent to Department 100.
All right.
Before you leave,
Thank you,
Your Honor,
counsel.
I'd like to ask Mr. Douglas to call Mr. Dershowitz, the practitioner, because we want, before Your Honor makes any final thing, a chance to get our some cases for the court. As you know, during the break, we did speak with Messrs. Dershowitz and Jerry Ullman. And so we'd like for you to have those before you make any final ruling.
All right, I was anticipating taking the matter under submission, doing some research over the lunch hour, and ruling this afternoon.
We'll have whatever you have by that time, Your Honor.
All right, Ms. Clark, if you have some other authorities, you can give it to Mrs. Robertson.
Thank you.
Fine, Your Honor. Your Honor, can I say one last thing?
Yes. No, actually, no. I've heard enough.
All right.
It's just that naturally polite reaction that I have.
Your Honor, do you want to wait on other testimony until you resolve this issue?
I think we need to resolve this issue first. This is sort of, I'm required to rule on this issue once it's been presented to me, and that takes precedence over all other issues, so this has to be determined at this time. All right, we'll stand in recess till 1:45. All parties and counsel are again present. The jury is not present. Sorry to see the district attorney can't pay their lawyers enough to buy jackets.
One is being sent out, however, Your Honor.
All right. As to the recusal issue, actually, I see we have Mr. Schwartz and Mr. Regwan present in court. Counsel, yesterday we had counsel for Mr. Furman in court yesterday asking for the court's assistance to get copies of the transcript and the audio tapes. It's my understanding that your client is willing to display the transcript to Mr. Furman and to make available for their listening the tapes. However, you are not willing to provide any additional copies, but you give them the use of your conference room or your office to do that. Is that correct?
That's correct, Your Honor.
All right. I'll have Mrs. Robertson then communicate that to Ms. Butler and Mr. Tortolo. All right. If we have your card, correct? All right. All right. Thank you, gentlemen. Appreciate your cooperation on this matter.
They're here for also another reason, President.
No.
Let me just indicate that. We got some- They have the, pursuant to the subpoena that we obtained in North Carolina, the one you issued, they have the tapes. And what I would ask the court to do is have them leave them with the clerk, and I've asked for some further time to discuss a proposal I have for the court. Just put it in Your Honor's clerk's custody at this point, and then we'll address the issue of redaction after that.
All right, then, gentlemen, at the conclusion of the session today, I'll direct you to turn those materials over to Mrs. Robertson. Mrs. Robertson, I'll direct you to place those items under lock and key. All right. All right, Mr. Cochran, you said you had some other proposal?
Yes, I do. I have proposed the court may save some time. And I wanted to get this to the court. First of all, Your Honor, we used our time hopefully wisely over the lunch hour with regard to these tapes, the Laura Hart McKinney tapes. And what I'd like to propose is an offer of proof. This is our part of the case, and I'd like to propose an offer of proof, which I think is appropriate under the circumstances, and share some additional facts with the court. I'd like to further back this up with a written, detailed offer of proof, which we'd be prepared to file with this court by tomorrow morning. But I can tell you pretty much what it is. We spent the time researching. Let me proceed as follows, if the court pleases. As far as Mr. Simpson and the defense, we contend we should be allowed to proceed as follows. We have checked these tapes out, and there are at least 30 times when the so-called N-word is used to refer to either suspects, regular citizens, city council people, anyone in disparaging terms. There are at least 17 instances in these tapes in which Detective Furman admits or approves of planting, manufacturing evidence, lying, or covering up police misconduct. At least 17 instances. And in one instance, he describes himself as a key role in covering up a situation, Your Honor.
Mr. Cochran, forgive me for interrupting you, but this is sort of the offer of proof that you need to make to the person who will make the materiality call.
Well,
so I thought you were going to propose another method of evaluating that issue.
Well, I will do that, but I'm saying to you, once you hear this offer of proof, it's back to our additional position I made this morning, that there's no reason to send it out. And if you do send it out, then send it out only, here's what we propose. Assume, arguendo, that based upon this, the 30 instances of where the N-word has been used, or at least 17 instances where this officer has talked about lying, covering up, beating people, and that sort of thing. Assume that that is relevant, okay? Then, under that scenario, let them argue that Margaret York is material. Because you're going to say, we're going to waste all this time. I mean, in L.A. County, I can't believe the Board of Supervisors are hearing this. They must be really shocked out of their minds, because how could you then pull a judge off another case, ask them to read this entire transcript for something they will never be able to get in? This is a waste of time. And it's ironic that we're the ones bringing this up, it seems.
Mr. Cochran, here's the problem. The problem is this. They raise the argument, they raise the issue that because the court is now aware, based upon the offers made both by you and by Ms. Clark, that Mr. Furman has made comments disparaging of this court's spouse. Would a reasonable person with those facts suspect that the judge might have difficulty in being fair in evaluating the materiality of impeachment testimony with regards to the person who was alleged to be making these disparaging remarks?
Well, let me answer that. Well, you know what? When I told you this morning how this man disparaged everyone, went back through the transcripts also. Well, you're not going to be able to send it seems to me, necessarily to people in this county. Let me read something for you. May I, Judge, I'm up to discussing. May I proceed? May I proceed, Your Honor, please? Every judge of the Superior Court and Supreme Court, I don't know what the Supreme Court or the Superior Court says, and I really don't give a blank. That's how he refers to Superior Court judges in this county, and to politicians and everyone. He has something for everybody. So, I mean, it may be your wife, but he has just as little regard for Superior. I suppose that a judge who sits and listens to that on the tapes, and I quoted from the tapes, they're not going to be very pleased with this man either.
But the problem is my wife is apparently referred to by name, by rank, and by
She is?
assignment, contact with this person.
She is, but I think that he also refers to Superior Court judges in this county. He has no respect for anyone. So I'm just pointing out to you that it's not going to be easy for you. If you want to send it to a woman, he doesn't like them. You want to send it to a black, he doesn't like them. You want to send it to a Mexican, he doesn't like them. He doesn't like anybody. Doesn't like Jews, doesn't like anyone unless they're white Anglo-Saxon police officers. And that's the problem in this case, Judge. And so I just wanted to point that out to the court.
All right.
Now, and so let me just pose this. This is a fallback. I don't think you should send it anywhere, because I think it's a waste of time. If you are going to send it anywhere, then I think the court should carefully, and with the assistance of counsel, tell this jury something about this delay that is not the defense, number one. Number two, if you're going to send it anywhere, you should send it only under the scenario I talked about, that you assume that what we've said is material and relevant, we'll prepare something in writing. Then let the people put up or shut up. Let them talk about how your wife could possibly be relevant. If the judge finds that Margaret York is not relevant or germane, even in rebuttal, then send the case back. And then we get on track and keep going. That's what we're trying to say, Judge. You understand what we're pushing and trying to say. And I think that, I hope I succinctly have stated this as well as I can, but I'm telling you, you're going to have a problem no matter where you send this case. Without going into more detail, that's what we propose. May I have just a second, Your Honor?
Sure.
All right, good breaking point. I got so pulled in, I forgot what time it was. All right, guys. I can't believe we made it through both live streams already. That went so fast. Jeez. Okay, then I guess I'll see you tomorrow. right? Thanks for coming out. I appreciate it. All of our hard work is starting to pay off in this, because this is the good stuff. Except we do go back to the forensics a little bit real soon. It's the OJ trial. It's all mixed up. But I will see you all tomorrow. Thank you so much for coming out. I appreciate it. I hope that you guys have a great day. Bye, guys.